Welcome to the October 25th, 2022 Zoning Board of Appeals meeting of the town of Raymond. The zoning boards of appeal will come to order. The board does have a quorum. I am now going to do a roll call. I'll go ahead and start. David Murch,
Greg Dean.
Hennessy.
Ed Mella.
Peter Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes from the September 26, 2022 special meeting, as well as from the September 27, 2022 regular meeting. Old business, acceptance of findings of fact for the following table at September 27, 2022 meeting. Administrative appeal, re-notice of violation issued 1/28/2022. Applicant Leah B. Rachin, Esquire, on behalf of Management Controls. Second will be a public hearing on the following table at the September 27, 2022 meeting. Administrative appeal, re-notice of violation issued 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine, location 28 Whitetail Lane. And then we will have adjournments. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, address, and affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board is formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So for the board, onto our approval of minutes. Assuming you've all had a chance to read the September 26th and September 27 meeting minutes. Can I get a motion to get those minutes approved?
So moved.
A second?
Second.
Do we have any further discussion or comments with regards to those minutes? Okay, I'll take a vote in favor of accepting those. David Murch, yes.
Greg Dean, yes.
Hennessy, yes.
Ed Mella, yes.
Peter Lockwood, yes.
Okay, very good. Unanimous. Moving on, we have for old business acceptance of findings of fact for the following matter table at September 27, 2022 meeting. Administrative appeal, re-notice of violation issued 1/28/2022. Applicant Leah B. Rachin, Esquire, on behalf of Management Controls LLC, location 28 Whitetail Lane, map lot 001020, zone LRR2. Description, administrative appeal from a notice of violation. Can I get a motion to take this off of the table?
So moved.
Any seconds?
Second.
All those in favor, David Murch, yes.
Greg Dean, yes.
Hennessy, yes.
Ed Mella, yes.
Peter Lockwood, yes.
Okay, at this point, I'd like to ask Attorney Wagner to sort of guide us through next steps, please.
Sure. So by now you should have received by email from me earlier today a draft decision pertaining to summarizing the deliberations and tentative decision that this board made in regards to 28 Whitetail Lane and the notice of violation for that property for Management Controls LLC. Have you all received and had an opportunity to review that?
Yes. Yep.
Yes.
So now I would suggest you just confirm whether you have any substantive disagreements with the findings and conclusions and ultimate decision presented here, or any additions or edits. You can flag any typos or non-substantive matters to me by email if you'd like, or send them to Sandy, and we can take care of that as this gets finalized in the next 7 days. But for now, if you have any substantive issues, I would suggest you raise them.
Yeah, I know from my end of things, I do not have anything like that. Any of the other boards?
I don't have any.
I don't have any.
No, I have none. I'll send my typos to Sandy.
Thank you, Tom. Okay, so seeing none, I would, sorry, Attorney Rachel.
Yeah, I'm sorry. I was just asking for a bit of clarification. Obviously, it's clear that we don't agree with these findings, but there was one issue, I think, on page 8 regarding whether violation number 9 should be upheld. And I believe there was discussion about consolidation with number 8. And I'm not sure, I don't see really much address of violation number 8. So I'm wondering whether that was intentional, because of course we appealed, I believe we appealed violation number 8 as well, and I don't know what the intention of the board was with that respect.
Sure. Let me explain what I think I've done with that issue, and then I would, turn it to the board to see if they think it reflects how they resolved that. So starting on page 8, footnote 2 reflects that the board allowed evidence pertaining to violation 8, but does not address the specific violation independently because it concludes MCL failed to raise that issue in its notice of appeal. And then I believe it's later on in section 10, the board addresses the argument from MCL that violations 1, 2, 4, 5, 6, 7, 9, 10, 11, 12 should be struck on the basis they're subsumed or duplicative of violation 8. So I think that's where we address these issues, or were you anticipating a separate section on the consolidation of 8 and 9?
I was just confused because there was no specific finding with respect to violation number 8.
Okay, I think there's no I'm suggesting there's no specific finding because the board concluded that MCL failed to raise the issue.
Okay.
So certainly if the board shares the concerns that that's not clear, I could make it explicit that violation 8 is upheld.
I mean, to me, the footnotes and the further comments were sufficient, but if anybody has any concerns, board.
Okay, I think that's a issue I can take a closer look as we do the final editing, but I think the board is clear that they felt it was not raised, and that's why it was not addressed, and that effectively means it is upheld. And I'll make sure the decision clearly reflects that. So thank you for raising that issue.
David, this is Tom. The note I took was we did discuss violation 8, and we did take a vote that there was no appeal, so we moved on from there and had a 5 yes, 0 count.
I guess when I was reviewing it, I think on my advice, which maybe in hindsight was not wise, was that you didn't need to take a vote on that because you concluded it was not raised. So if we want the decision to reflect a vote, that violation 8 is upheld because it was not timely raised by MCL. I suggest that we do that now, and then I can clarify that in this decision. Is that something you'd like to suggest, Tom?
Yes, and I'm sure Sandy can look at the video and validate that.
So Attorney Wagner, you're suggesting we take a vote on it right now? Yeah. So does somebody want to make that motion?
I guess it would be a motion to uphold violation 8 on the basis that it was not raised in the notice of appeal.
So moved.
Second.
So I think we have a motion and a second. Any further discussion?
Oh,
David, I guess you are saying those words. I just.
yeah, I was looking for a second. I'll second it since nobody else will. Do we have any further discussion? Okay, all those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Emily, yes.
Steve Lockwood, yes.
Okay, I will make that addition. Any other revisions? Seeing none, I'd suggest a motion to grant the appeal in part and deny the appeal in part based on the findings and conclusions summarized in the draft decision before you.
Sorry, David, I think your audio, it looked like you were,
Okay, hold on.
we got you now.
I don't think my dogs are in here, so we'll see how this goes. So can you all hear me okay?
Yep.
Okay, yeah, I forget where we're at now. So did we,
Looking for a so moved on my motion to grant the appeal in part and deny the appeal in part based on the findings and conclusions summarized in the draft written decision before you.
So moved.
I will second. Any final discussion? All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Steve Lockwood, yes.
Okay, that's unanimous. So I will work to get a final version of this decision in Sandy's hands in advance of Friday so that she can collect all your signatures, and we can get this circulated within 7 days tonight.
Awesome. Thank you. Next, we have public hearing on the following item tabled at the September 27, 22 meeting. Administrative appeal, re-notice of violation issued 3/10/2022. Applicant Gregory P. Braun Esquire. On behalf of Big Lake Marine LLC, Robert Durant, member and manager. Location 28 Whitetail Lane, map lot 001-020, zone LRR2. Description, administrative appeal from notice of violation. Can I get a motion to take this off of the table?
So moved.
Can I get a second?
Second,
Any further discussion? All those in favor of taking off the table, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Steve Lockwood, yes.
Again, Attorney Wagner, if you want to take us through some of the procedural steps. We've also had some information submitted today from Attorney Braun for request for inclusion with tonight's meeting. So if you could work us through that as well.
Sure. So as before, this is a de novo hearing on an administrative appeal. This means you can take new evidence, undertake your own independent investigation of that evidence and law, and make your own decision by identifying the issues raised on appeal, making factual findings relevant to that issue, apply it to the applicable law, and make your ultimate conclusions. I suggest, as before, we start with confirming that we have a quorum of the 5 members participating. I think I can represent that we do. The quorum's been established. I'll represent that the application, unless there are any objections from the parties, that the application was timely and complete.
No objection from the town, with the caveat that I intend to make a motion to dismiss in part for failure to comply with the rules.
Okay. Is that a motion that we should address here at the outset? Would it?
I'd be happy to raise it now so that we can.
I think that's appropriate.
Okay, very good. This is a motion similar to I've made in the past. I just want to make a record of it. I'll try to be brief. The town makes a partial motion to dismiss Big Lake's appeal as to the Whitetail property for its failure to comply with the appeal procedure set forth in the applicable ordinance. Section 16G3A2 of the Shoreline Zoning Ordinance provides that appeals are made by filing a concise written statement indicating what relief is requested and why it should be granted. Big Lake Marine's appeal does not state the grounds on which it makes the appeal. As to the Whitetail property, the appeal only, quote, denies the allegations that it violated the Shoreline Zoning Ordinance and denied the allegations contained in the notice of violation as to violations 1, 3, 4, 5, 8, and 9. And the town contends that the appeal ought to be dismissed as to those violations for Big Lake's failure to describe why the appeal should be granted. Thank you.
Attorney Braun, do you have a response?
Yeah, similar to past hearings on this specific issue, I would note that notice of objection to or appeal of any specific violation is generally deemed to be sufficient for the purposes of this process. That's how this board is previously and consistently ruled, and that would be the extent and complete.
Okay. Attorney Rachel, do you want to weigh in on this? No. So I'll turn it over to the board.
Yeah, I would agree with Attorney Braun that they've indicated that they want to appeal this, and they're here tonight to present a little further information. But I'm okay with what was presented within the document that was initially provided. Does any board member feel otherwise?
Are you asking about the original appeal document?
Correct. Yeah.
I don't have anything, Dave.
Good to move forward as is, Attorney Wagner. Do we need to take a vote?
Yeah, I would suggest a motion. You can frame it in the positive as a motion to grant the town's, move to grant the town's motion to dismiss the appeal on the basis that it did not provide a concise written statement. And that can be seconded just to square it up. And so then a no vote would be agreeing with Attorney Braun, and that would be consistent with the board's past decision on this point.
So I'll do a so moved. Can I get a second?
Seconded.
Okay, we'll take a vote on this. David Mertz voting no.
Greg Dean, no.
Tom Hennessy, no.
Fred Miller, no.
Pete Lockwood, no.
Okay, so that is unanimous and will be noted in the decision.
And then I would just like to make one additional comment that may help speed things up in a small part. The town withdraws violation number 5 as on the notice of violation.
Thank you for clarifying that. So again, I would assert to the board that we have a timely application, now complete application, and the board has jurisdiction, and Big Lake Marine as the subject of the notice of violation has standing. Does the board agree with those findings?
Yes.
Yep.
Okay, they will be reflected in the written decision. Finally, just to confirm again, as we have before, does anyone have any, believe they have any conflict of interest, any board members that they would like to disclose, or do any of the parties have any motions to that effect?
No.
Seeing none. So as before, as we go into the public hearing, the sequence will be the appellant represented by Attorney Braun to present without interruption, followed by questions from the board, cross-examination by the town of any witnesses put on by Attorney Braun, as well as an opportunity for the other party and with a re-examination by Attorney Braun. And then we'll proceed to the same process for the town, followed by a public hearing and then a rebuttal from Attorney Braun. As well as the town, and then getting, of course, Attorney Braun the final argument on the point. And then at that point, the board should close the public hearing and begin deliberations. While we're at the beginning of this, assuming that we'll get through the public hearing tonight, and that will proceed as we have before with making a tentative decision and instructing me to write up that decision. As you know, I've had some difficulty and failed in my task of finding a mutual date shortly after this to try to finish this up. So could I just pull the board members to see, is there a time in the next couple of weeks? I guess I'm going to specifically look at next week, week of the first week of November. Wow. First week of November, to see if we have a date that works for everybody to come and just confirm the written decision.
Yeah, I'm typically always available on a Monday night or Tuesday night.
Okay. I'll just go member by member if I can. So Fred?
The only night I see is Thursday night might be a tough night for me. But other than that, I'm open. That would be the 3rd.
Yeah. Tom?
I'm good except for Friday, the 4th.
Okay. Pete? You're on mute, Pete.
I'm good, except Monday, the 31st.
Okay, that's leaving Tuesday and Wednesday, and I've got a conflict Tuesday. So Greg, I'm hoping you can tell me that you are available on Wednesday.
I am. I have a conflict on Tuesday as well, but Wednesday's open.
Okay, well that's one Greg, and the other Greg?
Yeah. Yes, Wednesday's fine.
Okay, perfect.
So Wednesday will not work for me, but if a majority of the board can be there, then I'm fine with that.
Well, it would be the final decision, so ideally we'd have all 5 members.
Monday and Tuesdays are my free days.
All right, well, how about this? On Tuesday, is there
I can do any time.
do you need me on Tuesday? I suppose if it's a vote just to confirm a written decision that I provide in advance, would the board be comfortable proceeding without me there?
Yeah, from my perspective, yes. Obviously, the board can weigh in on that too.
Yeah, Greg Braun, any issues on Tuesday?
I could do it if it was after 7 o'clock. If it was a little later in the evening, I could likely make that work on Tuesday, or if we did it a little earlier in the day. But the 5 to 7 o'clock window is where the conflict, of course, is.
Yeah. How do the board members feel about a late meeting, say 8 o'clock?
I mean, for me, that would be fine.
I anticipate this would be the only thing on the agenda, so it probably wouldn't last very long.
Fine with me.
I'm okay with 8. I'm
How
okay
about
with
the town, Eric? Are you okay with that?
8 o'clock on November 1st would be fine.
Okay. All right, so I think we're good for, let's schedule that for 8 o'clock on November 1st. The only item on the agenda, as far as I'm concerned, would be approval of the written decision for this appeal. Sandy, I didn't check in with you. I assume that's okay with the town?
I have to look at the calendar, so I'm gonna try to do that now. Hold on.
Okay. If not, my firm can certainly host a Zoom for us.
Yeah, but we need to be able to have it recorded.
We can record it and send it.
Oh, perfect. Okay, let me just check.
Yeah.
Does it have to be broadcast?
Mhm. It does. We're operating under a remote proceedings. So as long as that link was circulated, I think would be sufficient, unless your policy specifically says it has to be broadcast on certain channels.
And David or Sandy, does this mean we would not have a normal meeting at the end of the month?
So just be a special meeting, Tom. Well, unless, unless nothing comes up for us to normally meet at, then I would say, you're right, we wouldn't have a meeting at the end of the month.
Okay, there's nothing on the calendar for the 1st. However, how are we gonna get this advertised in time?
Yeah, but it wouldn't be a public hearing. So is there?
So then we wouldn't have to necessarily advertise it.
Right.
Okay, then that's not an issue. And there was something else I was gonna raise, and when it pops back in my head, I'll get back to y'all.
Okay. So let's consider it a date for 8 p.m. November 1st for this item. So thank you, everybody, for allowing me to do that at the outset. And so I think now I would turn it over to Attorney Braun.
Thank you, Steve. And what I'd like to do is I'm going to ask Alex some questions, not an awful lot, but just a few on some of these notice of violations. The board obviously would note that the appeal it just had a finding of fact on is literally a carbon copy of the one which you're about to take up, but for the named party on that appeal. And so most likely, while this is a de novo review, and there are some specific facts or bits of evidence that pertain to a few of these allegations, it's reasonable to expect that the board would likely find exactly as it just did related to facts and the circumstances. That being said, we do get a fresh bite at the apple in this instance, and I hope that if you hear something that rings true or might persuade you to otherwise find in favor of the appellant, that you will. And so, Alex, if I can, I want to draw your attention first to notice of violation number 1, which is this allegation that a significant amount of soil disturbance had taken place within 100 feet of the normal high water mark. And in it, you had quoted or cited section 15, subsection U11 of the land use standards, the shoreland zoning provisions, which indicate that all activities shall be conducted in such a manner as to prevent erosion and sedimentation of surface waters to the maximum extent practical. This job, this project, it was commenced in or about September of 2021, correct?
Yes.
All right, so that's over a year ago now. And you have previously testified that you're not aware of any further work that has been done on site since you gave a stop work order in the end of October 2021, correct?
Correct.
Okay. Can you describe to the board what sort of erosion or sedimentation of surface waters has taken place since October of last year due to this project?
Well, that particular section is.
If I may just interpose for a moment. The question is whether there's a violation that existed at the time of at the time the notice of violation was issued. That's the issue before this board, not what has occurred since then.
Sure. Without interruption, I think that's what Steve said. I had a chance to do here. And as it relates to that, this specific ordinance requires two things: that there be a creation of unstabilized soil conditions and for which a permit was required. Alex, going back to the date of your stop work order, can you explain or provide to the board a description of what erosion or sedimentation of surface waters took place specifically because of this project?
Yeah, sure. So if you look at page 16 of the notice of violation, you'll see during construction there was a period of time where there was a incredible amount, or a pretty significant amount of disturbed soil present on site. And that work was being done without a permit or an approved erosion control plan.
Okay. Unstabilized soil. You use the word disturbed. All right. But it words are important here, right? The provision explicitly says unstabilized soil. And so again, I'm curious, what you actually witnessed as it related to erosion or sedimentation runoff, and what evidence you might have as it relates to those two specific issues or instances.
Yeah, so that would be Exhibit E on page 16. That's our evidence of that.
All right. Can you describe that for the board?
Yeah, I can definitely do that. So that would be this photo here, which shows the 28 Whitetail site with, this whole bank exposed, disturbed, unstabilized, and, vulnerable to whatever could occur environmentally in this type of situation. This particular section of the ordinance does require a permit for activity like this, and does require a plan to help protect the environment if something were to happen.
Okay. But again, are you aware of any actual erosion that took place because of this work?
I'm not necessarily aware of any, but I do think that kind of goes away from what the intent of that section of the ordinance is.
All right. So that's a no, correct?
Yes.
Okay. And similarly, you're not aware of any sedimentation of surface water that took place because of this work?
Yeah, I'm not necessarily aware of any at this point, but again, that's not why the NOV was issued.
Okay. Since the date or since the issuance of the stop work order, have you at any time since then made request of the respondent here to further create or put in place erosion or sedimentation control actions?
I would say somewhat. Part of the notice of violation does include some requirements to reestablish the site in a way that we feel is appropriate. So I think you could say yes, but what you're getting to, I think, is have we asked him to, reapply erosion control, a year later, and that we have not done.
Okay, and the town itself hasn't taken any of those actions either, correct?
Correct.
Okay, And so your testimony currently, the statements you're making here is that you're not specifically aware of any erosion or sedimentation of surface waters that's taken place because of this activity, and you have not kept secure or prior to your stop work order.
Can you repeat that back, because the whole thing was pretty broken up, unfortunately.
Yeah, gotta love technology. So again,
Yeah.
so since the stop work order, your statements here are that you're not aware or you cannot provide any evidence specifically of erosion or sedimentation of surface waters that have taken place since your stop work order, correct?
Yeah, I wouldn't disagree with that. Yes.
All right. I recognize we have there might be an argument, or you don't think that speaks to the heart of this citation, but just as it relates to the repercussions or what came from it. And
Sure.
again, you would just confirm that since your stop work order, you have not requested that the respondent take any additional steps to preserve the shoreline and or prevent erosion or sedimentation, correct? Nothing else has been done or asked.
In addition to what we asked for on the notice of violation, no.
Okay. And the town similarly hasn't itself taken any of those steps either.
Correct.
Okay. Drawing your attention to violation number 4, and I don't want to hammer this too hard. We've been back and forth over this a couple of times through different hearings, but this speaks to the definition, right, of a structure or use, right? And so in section 4, or in violation 4 here, you've indicated that the shoreline has been enlarged or expanded without a permit. Your position is that the shoreline itself constitutes a structure or a use. Is that correct?
Yes.
Okay. And what about this specific shoreline or job constitutes, or project constitutes, a structure or use?
Well, let me just see. I want to look up that section here because I don't have it right in front of me. So you are saying, yeah, and so your question is what constitutes, what would make this a structure or a use?
Yes, I mean, you issued this violation, so based on your
Mhm.
interpretation and the basis of the issuance of this notice, what about specifically this project constitutes a structure or a use?
Well, I mean, it's established on the table of land uses as an activity that requires a permit. So that's the baseline there that we use.
Okay, and what activity is that?
The shoreline work.
Okay, so it says shoreline work constitutes a use.
Yeah, so if it's actually the table of land uses, and if you look, 17A and B is temporary and permanent, and that's for temporary structures, permanent structures.
And so do you believe that this project was a temporary and or permanent structure?
I feel comfortable with that. Yeah.
Okay. Hypothetically here, what if rather than riprap, trees had been planted along the shoreline? Would that constitute a use or a structure?
I wouldn't say that trees would be considered a use or a structure, no.
Okay. What about fill? If soil had been planted or deposited on or along the shoreline, would that constitute a structure or a use?
I mean, you technically can't do that. So I don't even know if that example would necessarily apply in this particular situation.
So that's you don't know.
Yeah, I don't know.
I mean, is it fair to say that part of your opinion or determination here is based upon the materials that were used?
Well, it's more or less coming from 12A under C, section 15C.
Can you
There's
elaborate?
standards. Yeah, so there's standards in there for shoreland stabilization. That section there, that 12A and B, is really why this gets lumped into piers, docks, wharf, bridges, and other structures and uses extending over or below the normal high water line. There is language, there's rules in that section that fall under that, section C. And for some reason, that's why the state, they set it up this way, because it comes from Chapter 1000 guidelines. That on the table of land uses, it falls under that particular category.
Okay, but there is a difference between shoreline stabilization activities and efforts and what might be considered structures or uses, correct?
I don't think so. No, I think that's exactly the opposite of what this is saying, because this is a structure and uses section that is including language for shoreline stabilization.
All right. And so to be specific and just to make sure we're clear here in your decision making and the basis upon which the violation was issued, you believe that any shoreline stabilization project by definition constitutes a structure or a use.
It's required, it falls under 17, that on the table of land uses, which is for structures and uses.
So that's it. That's a yes.
Yeah, I guess if you want to say that, sure.
Well, and again, that's a.
I know, but the answer I'm giving isn't really a yes or no. So if you want to call it a yes, it's a yes, with the understanding that it's lumped in with other things that are not structures.
All right. So it's also fair to say that you don't know.
Yeah, I mean, I think that's open for interpretation. It depends on who's interpreting, I guess, on that one.
Okay. Related to violations number 6 and 7, which the board previously voted to consolidate into one violation and then to find that it had been committed as it relates to management controls in the last hearing. And again, I don't want to belabor this too much, but you indicate, in your allegation that all existing vegetation had been removed. I also recall that you testified that the root system of these plants and vegetation had been torn up and removed. Is that correct? Do you remember that?
Yeah, I think I remember something like that.
Okay. And that's in part the basis for your allegation that all of this vegetation had been removed. Prior to today's hearing, I had circulated to the board and to Attorney Wyckoff and to yourself, I think you were CC'd on it, some pictures which were taken earlier today by Mr. Durant on behalf of Big Lake Marine. And they demonstrated and showed quite a bit of grass that had regrown and filled the areas that you identified as having all of the vegetation removed. I don't know if maybe it's possible to quickly share my screen. Someone's got to give me the authority to do that.
You should be all set. If the chair is okay with that, I think.
Yes, from my perspective, that's fine.
we get into one of these dumb question moments. How do I do that? I don't see the button.
Would you like me, Greg, would you like me to share if that's appropriate? I could volunteer.
Yes, please.
Are you going to share the picture your exhibit A?
That's exactly right. And if you'd like to do that, that's, yeah, that
I,
works just fine.
I don't mind as long as everybody's comfortable with me doing that.
And just to be clear on this point, then, no one has any objection to us entering these pictures as an exhibit and part of the record for this proceeding?
The town does.
Okay. Maybe we
Happy
just-
Happy to address that if you wish.
Yeah, yep, please, Attorney Wyko.
The town objects to the photographs that have been submitted. That many of the photographs relate to the Fernwood property. They don't relate to the Whitetail property. And today's appeal is relating to the Whitetail property. So the photos that relate to the Fernwood property just have no relationship to this appeal at all. And there's no need, they should not be admitted because they don't relate to the issues in this appeal. And in that ground, the town would oppose their entrance into the record. And also, you know, it isn't really clear what they are. There's no one explaining what they are. They're just kind of put in a vacuum. And I think that's a problem. Another reason they should be not admitted.
Sure. So, Eric, if you can, which I've labeled each of these pictures individually as Exhibit A, B. Which one specifically do you believe relate to Fernwood and you would ask to be excluded?
A, B, C, D, E, I believe F, and I believe I, and am certain J, and am certain K.
Okay.
That's
So
my
then-
point. That's kind of my point. There's no one here to authenticate what these are and describe what they are.
Well,
And
the
they're
rules
just
of
in a
evidence
vacuum.
don't apply in this hearing. I've indicated to the board that these were taken by my client earlier today. And to the extent that, some of these are to the separate property, I would recognize that argument. I would say that it speaks, generally to the totality of the circumstances and the overall findings or allegations of the CEO. But certainly then, those others, have an argument to be let in.
Are you testifying as to what they consist of, Greg?
Well, I think they speak for themselves for what they are. And I'm saying I am testifying that my client took these today at the subject property.
And are you okay? And when you say subject
So
property, what do
listen,
you mean?
testifying, again, the rules of evidence don't apply here. I'm not a witness before this board. I'm merely presenting these photos for what they are.
That's my point.
Well, Attorney Wagner, can you sort of give us some?
Sure, yeah, I'll jump in, but before I do, Attorney Rachel, do you have any comment on this?
Yeah, just simply to say that I entirely support that those be submitted. If we look back to the notice of violation, let's remember that it's not just the actual alleged violations that are part of that document, but also the required remedial action or mitigation. And I think those photos speak very loudly as to the fact that much of the required restoration, if you will, you can see that Mother Nature has in fact restored those properties largely, and particularly with the earth moving and filling and the grass and there were allegations that throughout there were allegations that roots were removed. I believe that you can see vegetation coming up through that riprap. Had roots been removed, I'm not entirely sure if that would actually be the case. And so I do think they are very relevant because, as I said, that those multiple notices of violation required certain restoration. And as you can see from those photos, it is largely restored.
Thank you. Mr. Chair, members of the board, my recommendation is that you admit them, just because Attorney Braun is right. The rules of evidence here don't apply. What that's referring to is that typically in a trial, what you would see and what, frankly, the court would require would be that you have a factual witness that can provide testimony authenticating these documents, how they were obtained, what were the methods to show that they're accurate and would present them as facts. However, those same rules don't apply here. Moreover, as I've said previously, I think the standard that guides whether you should let something in or not is relevancy, and I think that's a pretty low bar. And just because it's not the specific property at issue, I don't think, for the reasons Attorney Rachel and Attorney Braun have said, that makes it not relevant. That being said, all the arguments that the Attorney Wyckoff has raised, I think, go towards the weight and credibility of the evidence, and you absolutely should consider those. And I think it's fair to say, as a general statement, a photo that's introduced without someone authenticating it is generally not given the same weight as a photo that's introduced and authenticated by a factual witness. So I think you should take those arguments that everybody made into consideration when evaluating the credibility and weight of the evidence. But credibility and weight are separate from admissibility, and that's why my recommendation is that you overrule the town's objection and admit all of the photos.
I'll make an motion to admit, to allow admission of the photos submitted by Gregory Braun today.
I'll
Can I
second
get a
that.
second on that? Yeah, do we have any further discussion? I guess from my end of things, I would, if we go through the photos, my preference would be to know which property they are associated with. If it's clear, I would like that information. But all those in favor of admitting the photos, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Eli Lockwood, yes.
So I think Attorney Braun, it's back to you.
All right. So Alex, all of these photos are in. I don't want to belabor this or take too much time with it, though. We don't need to go potentially frame by frame. I would, though, draw your attention to Exhibit H, which
Sorry
was
to
taken.
interrupt you, Greg, 1 second. Just to clarify, just want to make sure I should share my screen now. Is everybody on board with that? Okay. And you want to go down to H, you said?
Yeah, and I got that on page 8.
Okay.
All right, and Alex, quickly but to the point, you'd previously testified that all of the root systems of the vegetation along the shoreline of this property had been removed. You would agree that this picture 8, taken from Whitetail, shows not insignificant grass growing along the previously modified or dug up surface. Is that correct?
Yes.
All right. What kind of familiarity do you have with vegetation growth or horticulture, we'll call it?
I am not a professional by any means. I'm not necessarily educated on a college level when it comes to growing grass, but I do know, living in Maine and having lived in Maine my whole life, typically if you seed in the spring, grass is usually growing by the end of June.
Okay. Now, to that point, you placed a stop work order on these properties. Is that correct?
Yes.
Yep. And you did that back in October. And you previously testified that you were not aware of any work that had been done nor approved by the town as to either of these properties. Is that correct?
That is correct. Yep.
All right. And so you have, and you previously testified that you had no reason to believe that work had been recommenced or otherwise performed on the properties. That too is a correct restatement.
Yes. The only thing I would add is there is a couple of open permits for some activity that's been taking place on site, not specific to any site work. However, I would also add, I am aware that the property owner had at one point in time used a property maintenance company, I believe, or something, because at one point there was someone down there maintaining the property. Now the grass has been mowed, so.
And the grass has been mowed, you said?
Yep.
Okay, that obviously suggests or indicates that grass still exists in those places, correct?
Yep.
Okay. And you have no, you're testifying here, stating here that you have no knowledge specific to, the development of this grass to say whether or not this sort of growth and this sort of, we'll call it, growth could take place if there wasn't already a root system, underneath the soil and underneath what we see here. Is that correct?
Yeah, I couldn't tell you if this is existing roots or seeds that were planted in the spring. That's not something I could do.
All right. And to that point, just to restate, I believe you previously testified that as it related to this specific issue and the removal of vegetation, you kicked or you towed the ground. I mean, that is an accurate statement or description of your prior statements.
Yep.
Okay. And so if this grass was the result of existing root systems, you would agree that not all the vegetation was removed from the property or in these alleged areas. Is that also a true statement?
Yes, correct.
Okay. And Greg, thank you. That's all I'll need to do or want to do as far as review of these photos, given that they are in the record. Alex, I'd like to ask you a question as it relates to violation number 8 and violation number 9. And this has to do with stabilization of the shore front from the land, right? And from the land or no barge, right? Your interpretation of this section that you've cited, section 15, subsection C12, is that absent a permit, any and all shoreline work must be completed by equipment located on a barge?
Yes.
Okay. How do you define access?
Well, if the property is already cleared of trees and is relatively flat, I think it's easy for someone to assume that they could access the shorefront. However, from experience, most of the lots that need to be stabilized are not relatively flat and they're not easily accessible. Usually involves the removal of trees or vegetation to actually get to the shorefront.
Okay. All right. So you're indicating that usually there is some requirement or necessity to remove trees to get to the shoreline, correct?
Correct.
That in your experience as code enforcement officer, that's what you found.
Yep.
Okay. And in fact, if we look at this specific provision, it speaks to that, does it not?
Yes.
Okay. To the point there, it says, when necessary to access the area to be stabilized, any path must be no more than 12 feet in width. And when the job is complete, they must restore the access way. Is that correct?
Correct. Yep.
Right. So in your experience, and you've indicated here that the majority of the jobs related to shoreline stabilization have needed to make use of that sort of path. What sort of restrictions or requirements do you typically place on an operator or a construction or excavating company?
Yeah, so they would need to comply with all other applicable sections of the shoreline zoning provisions. I mean, obviously they need to be a DEP certified contractor, and they would need to, make sure they have a permit in place for the activity, a plan for how that's going to be done, erosion control plan, and they need to have a replanting plan for how that site would be restored, just to name a few.
All right. In those instances, does the equipment generally end up on the shoreline to do the work?
Yeah, it's not uncommon.
Okay. And so what you're describing here is a situation where an access lane is created so that the equipment can get to the place where the job's to be done, correct?
Yep.
Okay. you don't limit that access to the reach of the claw on an excavator, do you?
No.
Okay, so if an excavator or other heavy equipment needed to access the shoreline from one of these created paths, you wouldn't say that the path can only go as far as necessary for the claw to reach out and do the work necessary, but rather the equipment can be in that location.
Yeah.
Okay, so if we acknowledge that that's how you interpret and apply this provision to those circumstances, right? How do we say that to access a shoreline from a barge, right, requires that the equipment remain on the barge as opposed to simply be placed on and access the shoreline from the water?
Yeah, I don't think it really matters. I mean, I think that if it's possible to, accomplish the work, like for example, if there's an area that is more of like a sandbar where you can actually offload an excavator onto a sandbar, and that excavator can do the work from land without disturbing any vegetation, I don't necessarily think that's a problem. I think that would be okay with the ordinance.
All right, but here you say that it was completed from the land as opposed to from the barge. That seems to be the root allegation of each of number 8 and number 9. And I'm just looking, for the.
Yeah, I think, and I understand what you're saying. I think what you're trying to say here is we're implying that it should be done from the barge. I think really it's an issue with the wording of that phrase, and that's definitely on me. I think it really should be access from land or access from barge, which is probably a wording oversight when it comes to the language used. But I don't think that I don't disagree with your interpretation of how that section of the ordinance should be followed.
All right, but you've also you do know, and you've previously stated to this board that Big Lake Marine, Durant Excavating, Rob Durant, they have access to a barge, correct?
Mm-hmm.
And they generally place their equipment or get their equipment to these job sites via that barge, correct?
I don't know about that. I can't really answer that one.
All right. Well, you've presented and included pictures of the barge that they own as part of these notice of violations, correct?
Yep.
Okay. And it would appear to me, do you have any reason to believe that this equipment was brought to this location via the land and not from the barge itself?
Well, I mean, just in the last meeting, you guys said that it actually came down the hill, and that's why the grass was gone, because he was bringing in the equipment from there and parking it there when he wasn't using it. That's kind of anecdotally, that's kind of what we were told when we did our inspection last October as well.
All right. And so, all right. So your statements here, you're telling the board that you believe that we both represented at the last hearing and that Mr. Durant or Mr. Bateau had previously indicated to you that this equipment was brought from the land and not from the shoreline itself.
Yeah, no one has ever indicated to me that the equipment was brought in from barge.
All right.
And it's been over a year.
Okay. But you also agree that at least as far as the way these violations are written, is that doing the work from a barge as opposed to placing the equipment on the shoreline, that itself isn't really the nature, the intent of the ordinance, but rather it's how you get the equipment there.
Yes, and it's very uncommon, to see a situation where someone is going to do a restoration project of this size. So there isn't really anything I can compare it to in the previous 2.5 years in Raymond that I've had.
Okay. All right, moving on. Want to draw your attention to, and I'm just going to kind of lump them together here with violation number 10, 11, and 12, specific to the unpermitted tree removal. You indicated in the last hearing that you did not served notice of violation upon Q Team for the removal of trees at the Whitetail property because the owner or the principal of Q Team told you that they had not done the work. Is that correct?
Correct.
And that was the sole and exclusive basis for which you did not cite them for the trees removed from the Whitetail property.
Correct.
All right. Even though they did tell you and you did serve them notice for removing those trees at the adjacent property, which was part of this larger project.
Yes.
Okay. Board member Dean, if you would be so kind, and if the board would permit it, I'd like to share, I circulated again, emails by and between the owner of management controls, the owner of the properties, and Rob Durant related to the tree work. You'll recall that these were not admitted at the last hearing because that would have required the reopening of the evidence, and the board determined it was not necessary for their purposes there. But we are seeking to have these emails entered in this hearing.
David, how about you?
So, if you don't mind me jumping in, does the town have a response to the motion to admit these documents?
Yes, the town objects. Look, I understand the rules of evidence don't apply, but these text messages are one-sided messages going from Mr. Don Buteau to Rob Durant. We don't see any responses. They're hearsay. They don't have any foundation. We don't even really understand what they are. When you read them, they're confusing. They don't say what properties they relate to. So you don't even know what they are. And there's no one here to cross-examine and to understand, like, what do these even do? There's no foundation to explain how these fit in or what they are. You know, on their face, they don't say anything.
I mean, I object to that or disagree with that characterization. I think,
Right,
in fact,
if I can I just let Attorney Rachel weigh in so that you can then get the last word on that?
Sure. I do find myself agreeing with Attorney Wyckoff in the sense that it doesn't really say which properties, and you know, I only represent Q Team with respect to that prior appeal because there was only one, and I'm not really authorized to discuss anything here. But I mean, I will say one aspect of those texts that I think is relevant is that it talks about how management controls was checking in with Mr. Durant repeatedly about permits. So you've got those permits, you're working on the permits. So it definitely plays into the argument that he was relying on him to secure those permits. But with respect to what work was done by whom at what properties, I don't think they're particularly helpful.
sure. And yeah, I think, in fact, that they're abundantly clear in what they're talking about. There are no other projects between Mr. Bateau or management controls. No one has indicated that Rob Durant, Durant Construction, Big Lake Marine has in any way done any other work. They explicitly indicate that the properties in question are adjacent and that they'll be closing on the second one in the near future. And it makes it clear that Mr. Buteau has taken steps and made arrangements with Q Team to have the trees on both of these two adjacent properties removed. And so I don't think there's any confusion at all about what they speak to, nor do I believe that they're one-sided.
Thanks. I'll turn it to the chair to present this issue to the board.
Yeah, I there's a part of me that definitely agrees with Attorney Wyckoff. However, I do think, you know, these next three items in discussing whether they were, you know, done by Q Team or management control, I would rather have more evidence than less, and I would rather us as a board make a decision as to their, you know, how much they help us out. I personally would prefer to include the men. So I'm gonna go ahead and make a motion to include these emails as submitted by Gregory Braun.
Second that.
Okay, can we get some further discussion by the board as to whether you would agree to accept them or not?
Yeah, I think the phrasing that Attorney Wagner used for the previous question, I think kind of rings true in terms of admissibility is different from kind of the quality of the evidence. I'd like to hear it at least before we decide on the quality of it. And I feel like the bulk of the objection is about the quality of it. So it's kind of hard to even evaluate without admitting them.
You and I will.
Anyone else?
This is Tom, David. I reading them several times over, plus the time we had them the previous meeting. I don't really think it's absolutely clear which property they're referring to, and some of them don't even have a date on them, let alone talking specifically about Whitetail or Fernwood. So if we do admit them, there's still a lot of confusion that they don't make a lot of sense, especially when we're talking about, I think, Whitetail only. So.
Yeah, I don't disagree with you, Tom, at all. Pete or Fred?
And I kind of agree with Tom. I mean, one side of me would like to see him and hear it, but we don't know exactly what they're really talking about.
Right, I would agree that to me, they seem rather vague and unclear as to exactly, which property. So they don't do a whole lot for me as far as, providing additional information.
Well, the motion is,
Sorry, may I ask a procedural question before we?
please, Greg.
Yeah. So, Attorney Wagner, are we supposed to be examining the evidence in its contents to determine its admissibility at this point, or are we just examining kind of the meta data that's with the evidence to determine its admissibility? Because I think that's an important distinction to help me understand this decision. So if you could give some guidance, that would be helpful.
Sure. I think it's a very good question. We in some ways kind of have to engage in a fiction, and if you decide to deny its admission, you sort of wipe your minds of it. But I acknowledge that in a way you do have to examine it, or at least consider the descriptions of that evidence from the parties in order to evaluate its admissibility. So does that get at your question?
Yeah, I think so. You're still on mute, Dave.
Thank you. So we have a motion to bring these into our hearing tonight. So we'll go ahead and do a vote. David Murch is in favor of bringing these in.
Greg Dean, yes, bring them in.
I'm going to say no.
Fred Miller, yes.
Pete Lockwood, no.
Okay, so we have a majority saying yes. So we will review them. They will be brought in and reviewed.
All right, and to that end then.
Second, let me get it. Go ahead, Greg.
Sure. And so, again, understanding that the board may place different weight on the evidence before it, I would draw your attention to the first of these 3 pages dated August 16, 2021, which indicates that this is an email sent from Don Buteau as President Chief Executive Officer of Future Guard Building Products in Auburn to Rob Durant. That's indicated in both the to and from, as well as the signature block. And it clearly on its face says that we've decided to hold up on the driveway after talking to Q Team. They are going to send a crew there 2 or 3 days a week for the next month to remove 20+ trees that need to be out for construction. Now, based on the prior testimony of the CEO and the allegations contained in the notice of violations, I think it's clear on its face that 20 plus trees encompasses more trees than what might be present on just one property, right? They go on, Don Buteau does, to indicate a proposed time frame for this, meaning that it would be completed by mid-September. Again, based on the evidence that's been presented to this board, that clearly is in line with the start date of this project when Rob Durant Excavating, Big Lake Marine, whatever the town alleges there, came to and began its work on these properties. And it also then indicates that they're about to close next door on September 8th. And so once that's completed, they would let them know. Unequivocally and clear to me, this speaks to and is related to the shoreline work that's in question here. And by saying the property next door, I mean, I don't know how much more clearly you can indicate or suggest that this is the adjacent property. If we move on to the second message by and between these individuals, this one's from Don Buteau to Rob and Heidi. It indicates to them, right, and again, in a manner that suggests that neither Rob, nor his partner Heidi, for whatever purposes here, and she's not related to the businesses, but to Rob, that Don is in charge of and responsible for the procedures or the processes in place to remove these trees, and indicates that they will all be removed in the next 2 weeks. Again, indicating that they're closing on the next door property and that they'll get the tree work there done right away, right? Once again, speaks to the water level, which they indicate is crazy low, right? And so again, to suggest that this isn't clear as to what property it is or to whom it is they're speaking or what they're speaking about, I mean, I think that's turning a blind eye to very obvious facts. And then finally, the final email on page 3 of this indicates that he will have a crew down there. And this is dated finally in the middle of September, which is in line with the start date when Rob Durant went down there and began this work. And that they will have the far left property line completed and that they will be started and ready to clear or clear to start on that following Monday. And so these are emails by and between the property owner and Rob, within which and from which you can clearly see that the property owner is telling Rob that he is coordinating the tree work for both properties, that they are adjacent, one of which that he is in the process of obtaining. He indicates the number of trees. He indicates who it is that's going to provide or complete this work, that being Q Team. And he indicates that the completion of this tree removal by Q Team is essentially a condition precedent to Rob Durant being able to go down there and do the work. And so I think on their face, it's explicitly clear, given the timing, given the location, given the statements related to water lines and the level, the number of trees, that these messages are absolutely related to the work done at the Whitetail and Fernwood properties. And so I would suggest and argue here that these emails clearly indicate that Rob Durant and his companies did not remove the trees on either property. You'll recall the Q Team has already been found to have removed the trees on the adjacent property at Fernwood. And the only evidence or explanation that the CEO has given for why Q Team didn't do the work directly adjacent to the Fernwood is because they told them that they had. To argument, this is a bit of argument here, but I used to work with a prosecutor who used to call this I shot the sheriff defense. Essentially you find yourself in trouble for something. In this instance, Q Team is alleged to have cut trees and done violations on one property. So they're willing to take responsibility for it. I shot the sheriff, but I didn't shoot the deputy, right? I'm admitting to one thing, and in exchange for that admission, I'm hoping you agree and will acknowledge that I didn't do the other. And it rings hollow. And given the messages before the board, I think it's clear that it's untrue. And so we would submit these emails as evidence that Rob Durant, Big Lake Marine, Durant Construction, however the town would allege it, they've indicated there is no distinction between them, did not remove these trees and is therefore not responsible for violations 10 or 11 or 12. And with that, Chairman Dean, thank you for sharing your screen. I have no further questions for Alex Soroy, and I would turn it over to Attorney Wyckoff.
I think, Attorney Wagner, I think earlier you said that after Mr. Braun did the presentation, then you'd ask the board if they had any questions of Alex before going anywhere further. So I guess I just wanted to revert back to that.
Yes, you're correct. And sorry, Attorney Rankin, go.
No, I'm sorry. I didn't mean to interrupt. Again, I'm sorry. The procedural stuff eludes me. I just had like 2 or 3 brief follow-up questions for Alex. Again, I'm not sure the order of operations here.
Yeah, so I've got here what I read, which is questions by the board for the appellant, cross-examination by the town of the appellant's witness, then any questions of those witnesses by other parties, which will include you, and then a opportunity for re-examination by Judge.
Board, do you have any questions for Alex?
Is this for Alex or for Attorney Braun?
That's a good question, right? Who are
Who?
we asking questions?
I don't think we have to be that formal about it.
Okay.
Okay.
Sorry. I have a question. I'll shoot it to Alex to begin with, and maybe there'd be follow-up. But Alex, are you aware of like in Mr. Durant's, I'm not sure what business we want to call it, but the normal line of business, is tree removal something he normally performs?
Yes, I have been involved with projects before with this company where they have removed trees. This is common for them. One of their big things they do is septic systems, and they'll often remove trees within an area for a septic system, for example.
But for like a shoreline restoration or a big project like this, where you have maybe Q team who might be more of a tree removal expertise, would it be normal for multiple people removing trees across the big project like this, or would this be atypical, or do you not know?
Well, I mean, one of the things about Q team, having worked with them for a number of years, is they're very busy and they're scheduling months and months in advance. It wouldn't necessarily surprise me. This is speculative. I'm not really saying this on any facts, so take it for what it is. Wouldn't surprise me if just based off those emails, it looks like there was a situation where the property owner was waiting to close on a property and Q team was ready to go. Looks like they may have came in and did the first lot before the second lot was ready to be closed on, and they were off doing other projects and weren't able to get back for a few weeks. Is kind of what that looks like to me. So again, take it for what it is. I know they're very busy and they do schedule in advance. They often will submit 10 or 15 permits at a time. This, I think a few weeks ago, they mailed in, almost 10, in 1 month. So, yeah, it's not uncommon.
Great, thanks. That's it.
Don't think I really answered your first question, but if I didn't, feel free to circle back to it and I'll try again.
No, I think I got it.
David, I have a question for Alex, or
Sure, Tom.
depending on where it goes. Alex, having been to the site a couple of times, can you tell where someone was carving out 20 plus trees to put in a driveway? Which lot it was pertaining to?
No, I'm not necessarily sure what that is. I don't know enough to be able to answer that question, I guess, is what I would say.
But based on it being one of the first in the string of emails, you would presume it might be Fernwood.
It may be. I don't know. It looks to be, I mean, my honest opinion, reading those emails, it does look like it's all about Fernwood, but that's just, my opinion, and it doesn't really mean much in this particular situation.
Yep, and we don't have any of the parties represented here as direct witnesses that were on those emails, so we can't really get valid answers.
I mean, one of the things that stick out to me is on these emails is, you know, 2 of them are dated, you know, so the one on 8/16 from Dawn, and I mean, and the second part of that is, you know, are we getting the permits? You know, how are we making out on them? The next one, we don't really know when it was done, but we assume it looks like it's 11:32, I don't know, morning or night. Again, right off the bat, do we have permits? And then the last one that we do have a date on, which is 9/14, we don't even talk about permits. So somebody must have maybe come up with the answer, or I don't know. I don't understand why we start worrying about permits. And again, I don't know which property we're talking about. I mean, when we look at the pictures in the previous on Fernwood, there was quite a few trees taken down there. I don't remember the count, but there was quite a section of trees on the front there that was removed. I don't know if it would do any good to look at them again, but that's probably close to 20 trees on that piece of property there. More so than, you know, again, I don't know much about whitetail because we haven't really been talking about it. So as far as the
I do find it difficult on distinguishing property. I also am curious with the last email, or it's says, "Hi Rob," and then one of the sentences, you are clear to start on Monday, but just start what? So I don't know. I do find it difficult to go through these and know specifically that we're talking with regards to these 2 particular properties. But anyways, anyone else? Any questions?
And David, I was just thinking, following up a little bit on what Fred was saying, like email number 2, like you said, we don't know what the date is. And it looks like these were like select emails that were chosen to present. Like number 2 says, "I look forward to hearing from you." So in a way, I would presume that there were additional emails in between these, but for whatever reason, they're not included in the evidence.
Yep. Okay, so that's board for questions for the moment anyways.
barely hear you, Dave.
Nope. Is that it for questions for the moment?
That's all I have.
Okay. Okay, so again, Attorney Wagner, that would mean we would turn it over to Attorney Wyckoff.
That's right.
All right, Attorney Wyckoff.
My thought is that assuming that, I'm curious if you're okay with this, that I forego cross-examining Alex now and then just wait until the town puts on its presentation so we don't duplicate and draw this out unnecessarily.
I agree.
Okay, and then beyond that, I object to Attorney Rachin asking Alex questions. She's not a party to this appeal. Her clients are not part of this appeal. She's not co-counsel for the appellant, so I don't think it's appropriate for her to ask him questions at all.
Can I address that?
Yes.
Thank you. So if passed as prologue, or I should say if passed as an example, I do recall that Attorney Braun certainly wasn't a party to the past proceedings and the last appeal, and he was given ample opportunity to ask questions. I literally have 2, perhaps 3 questions. I think in the opening remarks, I think by the chair and also by you, Attorney Wagner, I heard that there is an opportunity for members of the public. I am a member of the public, and I would certainly just like to avail myself of the opportunity that was given to other attorneys / members of the public in prior proceedings.
So I would recommend to the chair to allow Attorney Rachin to ask her questions over the objection of the town. David, you're on mute.
Okay, so yeah, I would agree, especially given how we handled the appeal prior to this one. So does this need to go to a vote, Attorney Wagner? So does this need to go to a vote, Attorney Wagner? or
No, it doesn't.
Okay, good. So I'm good with you, Attorney Rachel, asking those questions later.
Well, now, actually.
Oh, now? Okay. I'm not sure what the procedure was. or process.
I agree with that, you know, I don't want to unnecessarily delay this, but if it's two quick questions, I don't see the harm in dealing with it now, and the town can address it at its opportunity.
Okay, let's do it.
Thank you. Thanks so much. And lest I be accused of misrepresentation, there may be 3, not 2. So I'll be quick. This is circling back, Alex, to Attorney Braun's questions relating to whether or not this riprap is a structure. So just to orient you what we're talking about here and what my questions are. So you're considering, I think we've established that you're considering this rock riprap area to be a structure, correct?
Yes.
Okay. And also correct, would you agree with me that the riprap that was used in this purported structure was also considered to be fill, correct? Because I think one of the 1 or 2 or 3 of the various violations alleged that there was fill or earth moving in excess of 10 cubic yards, correct?
Yes.
And included in that calculation of fill was this riprap, correct?
Yep.
So you're considering fill also to be a structure?
Yeah, it's common with impervious surfaces in general. Like, for example, if someone wants to do a gravel patio or a gravel sitting area, we would consider that fill because it's a material that would be deposited on site, and it's also considered a structure in the shoreland zone because it's an impervious surface. Has to meet setbacks.
Okay, and I just follow up. Fill, I don't believe, I'm looking at the definition section, fill is not defined. Would you agree with me that that's accurate?
Yeah, so if someone's going to bring in loam to plant a lawn, for example, that's not considered a structure.
Okay, so fill, just to be clear, fill, if it is loam, is not a structure, but gravel or riprap is a structure?
Essentially, yeah.
Okay. And you'd agree with me that fill is, I know it's not defined, but I'm looking up on dictionary.com, a definition of fill is material such as gravel, stones, etc., used to bring an area of ground up to required level. So fill essentially is organic material, such as loam, gravel, stones, riprap, that kind of thing, right?
Yeah, I think in this setting that would be fine.
Okay. All right. So, but loam, just to clarify, loam would not be a structure, but somehow gravel or riprap is.
Mm-hmm.
Okay, thank you. Those are all my questions.
Okay.
Okay, so Attorney Wyckoff.
Okay, very good. I want to ask the chair a question before I get started here. In the past, we began by having Alex do a presentation about providing an overview of the facts here. And then after he did that, then we went into a presentation where he and I went through each of the violations. And my question is, does the board feel that it has enough memory of the past with Alex describing this violation, or would the board like him to go back and read it and describe and give an overview of it this evening first?
That's a good question. Is there anyone on the board that would like Alex to go through that presentation?
I know it's long, but I think it would be helpful.
And I would say that given that one member of the board, or at a minimum, one member of the board would like to see that, then yes, let's please do it.
Okay, then I'd like to ask Alex to pull up his Google slide presentation and provide an overview of the factual background here.
All right. I'm going to try and share this. Make sure I'm on the right thing. All right, so 28 whitetail. I'm just gonna try to, I'll go through this hopefully a little bit quicker than normal, but still kind of give you all the same points, since I know we've been through it a few times already. Obviously, violation was brought to our attention by Alexis Savavalos, DEP field agent, who notified us of the violation when she was on Sebago Lake. No permit had been approved or submitted by any of the contractors or parties involved. And so an inspection was held on October 26th. And we went out to both properties, but these are the photos specific to the 28 whitetail property. Going through the violations, filling and earth moving of more than 100 cubic yards without a permit. I think it's actually 10 over here. You've got a significant amount of soil disturbance that had taken place within 100 feet of the normal high water. And a majority of that buffer zone for this property, between the house and the water, was stripped of vegetation, regraded, or reshaped in some shape or form. Existing shrubs and lawn were regraded and stripped. As you can see here, this is essentially bare soil, and it was a relatively wet day when we went down, so you can kind of see some of the water on top of that. This is actually a photo that was taken from the Portland Water District drone in August of 2021. So this gets into some of the fill, the material that was brought in. Again, kind of to summarize, 10 cubic yards, that's your average size dump truck. One of those essentially goes over that threshold. Requires a permit from the code enforcement office, and you have to have, an erosion control plan, and you actually have to have that erosion control in place during the disturbance of the site. And the ordinance also requires that the site be, restabilized within a week. That's just to avoid what happens in October. Is a lot of times we get, like we've been having the last few weeks, a lot of rain. So that's why the intent is to try and stabilize the site as quickly as possible. So riprap was brought in, a pretty substantial amount of riprap was brought in. A good portion of the site was already stabilized and was probably in much better shape than a lot of the properties on Sebago Lake. So I'm not necessarily sure what the reasoning was for needing to restabilize again. The before photos look to be pretty stable. I don't see any erosion issues. So the boat launch, like we discussed at the last meeting, was a wooden structure, basically looked like two pallets end to end, used to lower kayaks, canoes, and rowboats down, so you don't have to carry them down the rocks and risk falling and breaking your neck. So that was obviously not a boat launch like you would think of for like Urama Beach and stuff like that, where you're able to drop a trailer down in. It was more or less to get small boats down. So that was obviously removed before we were able to ever get on site and see it ourselves. But we do have quite a few photos. I know Mike Morse, when he was working on this project, submitted some more higher res photos that we have of it as well. This is the after photo, which shows what was replaced, what the replacement was, which is now a stone ramp from the water to the top of the hill. You can see here, there was once a peninsula. You can kind of see to the right, this section of the lot stuck out in kind of a peninsula shape. And now it is actually straight across down there. The peninsula is no more. So moving on to the shoreline, here you can see in the red, this is the shoreline as it existed. Down near the water was pretty much all established rock as it existed before the work was done, with shrubs, trees, bushes, natural ground cover behind it. The after photo shows that all that vegetation was removed and replaced with a rock bank of riprap, completely across. I'm going to skip the beach since we've withdrawn that one. So moving next to vegetation removal less than 3 feet in height. The ordinance does not allow for removal of vegetation less than 3 feet in height within 100 feet from the water unless it's for an allowed use or something allowed by the ordinance. There are things in there that allow for vegetation removal less than 3 feet in height. For example, if someone's building a house or rebuilding a house and you doing an expansion, an allowed expansion, that would be an example where someone might be able to do that. So a good portion of this lot within 50 feet even, not even using 100, let's say 50 feet, was stripped of the natural ground cover. And going back to this first photo, these shrubs that once existed, some of the grass that was growing up in the riprap is no longer. Stabilization done, from land versus barge. This is what Greg Ron was discussing earlier. Rob Durant does have access to a barge. He's one of 2 contractors on Sebago Lake that I know of that actually has a barge. And it is frequently seen all over Sebago. The stabilization project was completed from land. Access was, as far as I've been told, from land. You can see in this photo to the right, the access way that was used from the driveway for 28 Whitetail down to the area where the work was done. Tree removal within 100 feet. There's a significant amount of large trees and then small trees as well that were removed, creating canopy openings that exceed 250 square feet. And again, I think, to follow up from last time, we talked about 250 square feet is not a very big opening. It doesn't take a very large tree to create a canopy opening of 250 square feet. So here we've got trees 1 through 4, 5, 6 through 9, 10, 11. This is the after photo showing where those trees were. And then in this photo, you can see 10 and 11, 12 and 13, and then 14. So a significant amount of tree removal. Quite a few of those trees were larger than at least probably 3 of them, just looking at this photo, were greater than 12 inches in diameter. They're pretty good sized trees. Oh, I don't know what's happening there. I'm going to try that again. All right. So next is vegetation removal in excess of what's allowed by the point system. Point system, essentially, you have a 25 by 50 foot grid. This is for selective removal. If you want to remove trees within 100 feet and that tree is not dead, dying, or dangerous, you have to meet the point system. This is for anyone within 100 feet on Sebago Lake or any other great pond. You have to establish a 25 by 50 foot grid, and then you have to plot every single tree within that grid and calculate its diameter at 4.5 feet, above ground. So each tree diameter correlates to a point, and you have to have 24 points within a 25 by 50 foot grid. You have to retain 5 saplings. That's trees that are less than 2 inches diameter. Anything in excess of the 24 points can be removed as long as you maintain the 24 points, and a certain percentage of the trees, the points that remain, can't be, like for example, you can't have 3 trees that are all 12 inches or greater in diameter. you have to keep some smaller trees to kind of keep that even. So, for example, the section over near the wooden deck where basically everything has been removed, you know, it's pretty easy to establish that you've exceeded what's allowed by a point system when there's nothing left in a grid where there was once one tree. If you have one tree, you will never have enough points. It's mathematically impossible. You'd never have enough points to remove anything based on selective removal. Hazard trees are different, but again, like we've discussed before, we are unable to determine that these were hazard trees because we were not brought in to the site beforehand. So that is it for the presentation.
Okay, very good. Thank you very much, Alex. May I share my screen of my PowerPoint presentation where we can walk through the violations and address the arguments that have been raised in the appeal and previously?
Yeah, please do.
Okay, I'm going to go ahead and do that. Okay, can you see my PowerPoint presentation? Yep. Okay, great. Thank you. Okay. Before we get into the violations individually, Alex, I just wanted to ask you, as the code enforcement officer, can you describe what qualifies you as a code enforcement officer?
Yes, hold on one. Okay, sorry, can you repeat that question?
Yeah, sure. Could you describe what qualifies you as a code enforcement officer?
Yeah, so I am a state licensed code enforcement officer. So we are required to pass a few tests at the state level in order to be certified as a CEO. Legal issues, shoreline zoning, you know, are the two big tests. And then you have to be appointed by the municipality that you are working in, which I am. And then you're a code officer.
And you have a certification as one?
Yes.
And do you have to do any kind of continuing education?
Yes, the state does require, there is a continued education program we have to maintain. We have to basically get so many credits each year in order to maintain the certification. And I believe it's a 5-year cycle.
Okay. How many times have you visited this site, the whitetail site?
I have been down there myself 3 times.
Okay. And has anyone else from the town also been to that site?
Yes, my assistant, Chris Hansen, has been to the site at least 5 times. I think he's actually been more than 5. He's been there more than I have.
Okay. And can you just describe when he's been to the site, what has his activities consisted of?
Yeah, sure. He's done in 2021, he did 2 inspections, both there with DEP. Since he went down in 2022, once with me to do a site visit, again with DEP, and 2 other times. One time was to go do an inspection of the house at 28 Whitetail, and the last time was I think actually was also with DEP staff, if I remember correctly.
Okay. And when he visited the site, did he perform any measurements?
Yes.
Okay. And he verified all the necessary distances that are contemplated by the ordinance?
Yes, he when he went down with DEP in 2021, November 3rd, I believe, 2021, he went with Alexis Savavlos and Jeff Kalinich of Maine DEP, and I believe it was just the 3 of them that day. They did take quite a few measurements of the site.
And as your understanding, he prepared some notes relating to those visits and the measurements?
Yes, we have a paper file and a digital file. He does have a notebook that he's kept with some of his field measurements.
Okay. I provided a copy of those notes to the board earlier today, and I just want to display them if it's fine with the board, and have Alex verify that's what they are.
And I'd like to speak in opposition to that.
So Attorney Wagner,
Yeah, I would let Attorney Braun state the basis for his objection and allow Attorney Rachel then to respond if she add comments if she wants to, and then give Attorney Wyckoff the last word before the board takes that issue up. So Attorney Braun.
Yeah, so as it relates to these notes and these steps and actions that other individuals took, again, they're not here to testify or to speak to them. This is all hearsay, as Attorney Wyckoff has previously pointed out, related to emails or other evidence that we've sought to introduce. Really, the reliability of them, clearly the weight that should be attributed to any notes taken by some third party that isn't present, should be, grossly limited in what it is. And we would, clearly argue that they should not be allowed because there isn't anyone here to testify or to speak to the validity of what Alex is speaking to.
Attorney Rachel, anything to add?
No, I simply echo Greg's submissions for all the reasons that we've been talking about. The reliability is the weight that should be ascribed to them is, featherweight. But the other thing I wanted to say is I think I heard either Alex or Attorney Wyckoff mention that there's electronic records here. These are just handwritten, so there's no way to independently verify the dates that are put on them. I'm just curious as to whether the electronic versions, which I would imagine would have such independent verification, those aren't being submitted. So I would just ask the board to consider that when they're considering what weight should be ascribed to these documents.
Attorney Wyckoff?
Yes, thank you very much. So in the prior hearings that we've had, in which the records are all part of the same record for this hearing, there was evidence provided about the validity of using a measuring app or various types of applications, and all of those were out of court statements by people we know not. And here, this is better. These are notes prepared by an employee of the town that Alex works with, and is a record of that employee's, the assistant code enforcement officer's work on the side and measurements and whatnot. So I'd submit that, the indications of reliability are there and that they should be admitted.
Well, I would just object or point out that Attorney Wyckoff says these are better. There is no indication or reason to believe that these are better. So just again, to the extent that weight
really
might be given to them.
Objection. I think you're just taking another shot at the argument here. I think the issue is clear for the board. So I'll turn it to the chair as to whether to admit these documents or not. My advice remains the same, to admit them for the reasons I previously explained.
You're muted, David, if you're talking.
all right. So I will make a motion to introduce the notes as provided by Attorney Wyckoff. Can I get a second on that?
Seconded.
Do we have any discussion, board, before we move to vote? David Murch voting in favor to accept them.
Greg Dean in favor.
Tom Hennessy in favor.
Miller, yes.
Lockwood, yes.
Okay, you're good to go. Attorney
Okay,
Wyckoff.
thank you very much. I'm going to display them. And Alex, can I just have you verify that these are the notes that were prepared by Mr. Hanson?
Yes.
Okay, and they're 2 pages long.
Yes.
Okay, very good. Thank you.
I'm gonna object to that there. There are blacked out sections in those documents.
Yeah,
There's no
they're
explanation
redacted.
of what that is.
Yeah. I redacted privileged, a record of a privileged conversation.
All right, so, but these are documents that are not being authenticated by anyone else. They don't, there's no one here that can speak to them. And it's concerning to me, and it certainly would speak to the weight of the evidence that there are redacted portions of them when there isn't even anyone otherwise here to verify their validity.
I mean, I can verify their validity as this is my employee.
So if I can just jump in, I think that those, our arguments go again to the weight and the reliability, and Attorney Braun, I think you can, address those in your opportunity next to speak, but I don't think we need to go through further objections here. I think the board is clear and it's the evidence, and it's perfectly capable of evaluating its authenticity and reliability.
I would agree. Thank you, Attorney Wagner.
Okay, thanks very much. I'd like to move on to violation number 1. So this violation relates to filling and earth moving, which occurs in violation of section 15U1 of the Shoreline Zoning Ordinance. And the ordinance requires that kind of work be done in a way to prevent erosion and sedimentation of surface waters, and requires that if a permit is required, then the activity must be done in accordance with an erosion and sedimentation control plan. And for the reasons that the board upheld violation 1 and the notice of violation of management controls, you should also uphold this violation here today. Now, Alex, we'll get into this in a little bit more detail in a moment when it comes to violation 2, but this violation, it depends on more than 10 cubic yards of filling earth moving occurring, and that occurred, is that right?
Yes.
Okay. And so as a result, then the ordinance requires a permit from you to do that work?
Correct.
And what kind of erosion and sedimentation control plan was prepared or submitted?
None.
Okay. And what kind, how would you describe the adequacy of erosion and sedimentation actually measures that were taken in connection with the work?
Yeah, I mean, a silt fence was installed on site. However, it was not actually installed correctly in a way that was effective. Ended up falling down after, what apparently was just a couple of weeks' time, and wasn't tied into the to the bank correctly, and overall was inadequate.
Okay. And is there some documentary evidence of that?
Yes, that's on the NOV in Exhibit B and E.
Okay, let me go to that. Okay, can you describe this photo and what we're seeing there?
Yep. So you can see the silt fence on the right-hand corner of the photo, which has collapsed. And that should have been up on the stakes that you can kind of see there. And so that's failed.
Okay. Let me go to the other page here to Exhibit E. Okay. Can you describe this?
So this shows the site in activity. The area of greatest concern would be the area that's unstabilized or disturbed, and that's where they're actively working. You can see behind, near where the excavator is, all of the disturbed soil on the bank. The erosion control down at the bottom of the bank stops. Looks like they have a roll maybe laying on the ground there as they're going to continue running it. That's the area where it should be. And unfortunately, that's the area that it's not, and it should be in that spot.
Okay. Can you describe the second page of Exhibit E?
Yep. So you can see down in the bottom right-hand corner again, the erosion control that was set down below in that same spot as the last photo even is laying on the ground.
Okay. Thank you very much. Okay. moving on to violation number 2. So the ordinance requires a permit from the CEO for filling or earth moving of more than 10 cubic yards that occurs in the LRR2 zone. For the same reasons that you upheld violation 2 in the notice of violation of management controls, you should also uphold this violation. Alex, can you walk us through what this violation consists of?
Yes, I can. So exhibits A, B, C, and D on the NOV show that a significant amount of material was deposited on site to riprap over in spots where riprap already occurred, or actually bringing in new material. Like I discussed in the slideshow, the threshold of 10 cubic yards is pretty small. That's a single dump truck, and it's clear just based on the length of the bank that new material was brought in that it was multiple trucks.
So this is exhibit A. This is the before shot. Let me move to the next one.
Yep. So the entire grassed area next to the house, which we, it's, at least within 50 feet, probably up to close to 100 feet on this segment of shoreline has been disturbed and altered, stripped, graded. You can see in the after photo.
Okay, here's another photo from exhibit A.
Yep, that shows that same section that was previously vegetated.
And what's the earth moving in the fill activity that's occurring?
Yeah, so this section here, you can see all of the new riprap that was deposited on site. Approximately 6-inch rocks to 8-inch rocks. And this wall, measured vertically is 8 to 10 feet in spots. So it's a pretty significant amount of material that was brought in on this reshaped bank that was at one point a little bit steeper and shorter. The new bank is a little bit longer and taller.
So does that suggest there's also been regrading that's occurred?
Yes.
Okay. Another perspective. Can you describe what's occurred here?
Yep. So this area previously, like I think I went through on the slideshow, was a peninsula that jogged out.
Let me go back.
Sure. Yeah, here you go. This is a great photo. That first before photo on exhibit B shows where this previously jogged out into Sebago Lake.
Is this what you're describing right here, Alex?
Yeah, and now in the after photo, it's actually a straight line across, an even level line across where previously it jogged back.
Okay. Here's exhibit C. How does this show the earth moving and fill?
So the top of the bank looks, there's been a significant amount of mulch that's been brought in, which is also considered, a fill, a material. And then below that, you see all of the riprap rocks that have been deposited on site.
Okay. How about here?
Yeah, so this one shows, the scale of this area that was all essentially stripped of the grass. This was the section I was talking about earlier that was used as the area to bring in the equipment and store the equipment. But it's a pretty good size, section of the lawn that was completely destroyed.
Okay, thank you. One of the arguments that's been made here is that violation 2 is duplicative of number 1, and the board should reject that argument just as it did previously when this was raised with regards to the notice of violation to management controls. They're separate violations. Violation 1 is for filling and earth moving without steps being taken to prevent erosion and sedimentation, and violation 2 is for filling and earth moving that occurs without a permit. So they're really they're different violations. Even if a permit was issued for the filling and earth moving, there would still be a violation for the failure to take steps to prevent the erosion and sedimentation, for the failure to provide a plan. And additionally, if steps were taken to prevent erosion or sedimentation, or a plan was submitted, but the work was done without a permit, that would still be a violation. So they're really independent violations of one another. Violation number 3. This one relates to the enlargement or expansion of the boat launch at or below the normal high water line without a permit from the planning board. And for the reasons that you upheld this violation as to management controls, you should uphold it now as well. Now, I just want to point out this legal argument that the term structure is defined by the ordinance, and it's defined as anything constructed or erected on or in the ground. Now, Alex, can you just apply that definition to the boat launch, please?
Can you repeat that question? Sorry.
Yeah, sure. Yeah, the ordinance defines a structure as anything constructed or erected on or in the ground. And I was wondering if you could just apply that to the boat launch.
Yeah, absolutely. So that would be a structure that in this particular section remains in or over the water, as you could say. It's a functionally water dependent structure use. So it has to remain where it's located for more than 7 months out of the year, which makes it a permanent structure.
Okay. And it's a structure because it's been constructed on the ground, right?
Correct.
Okay. Now, the ordinance says that because it's a permanent structure, construction of it requires planning board approval. Alex, is there any record does the town have any record of a planning board permit for the boat launch?
We do not.
Okay. Now, the ordinance also requires that a boat launch have a permit from the Department of Environmental Protection. Alex, is the town aware of such a permit?
We are not.
Okay. So in the absence of those permits, that makes it a non-conforming structure. Is that right?
Correct.
Now, the ordinance says that non-conforming structures may only be expanded after getting a permit from the same permitting authority. So then as a result, expanding the structure also requires the permit. And this ordinance also says that non-conforming structures can only be replaced with a permit. Now, I'd like to have you go to Exhibit B, Alex, and just describe the change. Actually, before I do that, I want to show the board a photo of the original boat launch that was submitted to it by Attorney Rachin in September. And what this is a portion of an application submitted to the planning board by Mike Morris of Archipelago on behalf of both Management Controls and Big Lake Marine. And this shows what the boat launch ramp looked like before before it was expanded and enlarged. That's your understanding too, Alex? Is that right?
Yes.
Okay. Now I want to juxtapose that to what it looked like after the change. Bear with me, I'll get to that. And this is just another perspective on the launch before, and then here it is after. You could just describe that.
Yeah, so previously it was what appears to be 2 wooden pallets end to end. And typically a wooden pallet is about 48 inches wide. And like I said before, we were unable to do an inspection of the site prior to the work being done. So we don't have any field measurements of that existing boat ramp. However, based on the imagery and our conversations with Department of Environmental Protection staff in Augusta, it was very clear that this is at minimum a replacement, but is clearly in our eyes an expansion because it's definitely wider than 4 or 6 feet. It's actually closer to 15 in spots. So
okay. Very good, thank you. So then whether the work was an expansion or a placement, it required a permit and there wasn't one. So that's why this boat launch is a violation.
Mhm.
Okay. Moving on to violation number 4. This is for enlargement or expansion of the shoreline without a permit. And for the same reasons that you upheld this a violation 4 as to management controls, you should uphold it now as well. Now, the table of land uses in the shoreline zoning ordinance requires that where permanent piers, docks, wharves, bridges, boat launches, or other structures and uses extend over or below the normal high water line, that approval is required from the planning board. As I pointed out to the definition earlier, a structure is anything constructed or erected on or in the ground. So, Alex, if I could have you walk us through this violation. Could you do that, please?
Sure.
Let me go to, and should I go to Exhibit B for that?
Yes.
Okay. Oops. Hang on. Looks like I've got the wrong one. Bear with me. I apologize. Hang on. I'm going to stop sharing my screen. I got a little bit of a technical difficulty.
Yeah.
Okay. Sorry about that. I apologize. Okay. Okay, Alex, here's Exhibit B.
Yes. Yep. So this is showing the shoreline as it existed previously. And this is the after photo. Similarly to what we discussed a few minutes ago, there was once a jog where there's now no longer a jog. And that segment of shoreline has been altered and is now much lower down where it once, kicked back a little bit further.
Okay.
Here you can see you have a existing riprap retaining wall with grass growing. Looks to be pretty well stabilized, and they have placed this material on top of that wall, as well as the mulch above that. That adding of material on top is an expansion. It's additional material there.
Okay. You want to describe what's going on here?
Yeah, so if you look at the before photo, the area that's called out, and you look at the section that's closest to the water, kind of towards the left, you can see how short that portion of that riprap wall was previously existing. And now if you look down at the after photo, the section that's furthest out at the point, just look how large that is, how much higher it is. It's been raised up along that entire crown, of that peninsula, and all that material has been added there.
Okay, thank you very much.
Yep.
Now, Attorney Rachel last month provided a document to the board which had another things. Is that application that Mike Moore submitted on behalf of management controls in Big Lake, and I'm going to go to that. I'm going to go to that again. In that document is this survey that was submitted to the board, and I'm going to zoom in to, so we can see it. First of all, this survey is dated from December 27th, 2021, and I'm focused on this comment over here to the left-hand side. And the note is that the shoreline was regraded with riprap between the survey dates of June 2019 and November of 2021, which changed the horizontal location of the high water line. So in other words, this submission on behalf of management controls in Big Lake actually acknowledges that the work that was done pushed the shoreline out and expanded it. There's also a second survey that was also provided. This one dates from January of 2022. I'll show you that, the date. Okay, and has the same note right here that the shoreline was regraded with riprap between June of 2019 and November 2021 that changed the horizontal location of the high water line. So there really isn't any question that the shoreline was expanded here. Okay, as I mentioned earlier, the town withdraws violation number 5. Violation number 6. Now this violation relates to the removal of vegetation that is less than 3 feet in height with 100 feet of the normal high water line. And I guess first, Alex, well, why don't you can you walk us through what this violation consists of, please?
Yes, absolutely.
Okay.
So if we go to Exhibit D, you can see that there was once grass growing in this existing riprap wall. Ground cover less than 3 feet in height had reestablished itself in this area, looked to be growing pretty well. In the after photo, you can show that that vegetation has been pruned to prevent vertical growth or covered over, and it is no longer there.
Okay.
And here, same thing, you can see in the called out area in the before photo, there was once shrubs and grass growing in this area of the lawn. And at the time shown in the violation, all of this area was completely stripped and graded and disturbed without a permit.
Okay.
Again,
Well,
in
this
this photo shows the large area next to the house, same thing. And here, all of the existing ground cover at the closest point of the lot to the water, everything within 25 feet, has been completely removed and replaced with the riprap.
Okay. Now there were some questions that Attorney Braun directed to you earlier, and he tried to distinguish between removal of roots and removal of the leaf growth. And my question for you is, which of those or both of those supplies the basis for this violation?
You actually, so say that again. Sorry, I
Yeah,
wasn't
sure.
on.
Earlier, Attorney Brown was asking questions that candidly I think were designed to obfuscate. And he was asking questions about the roots were being removed, and then as compared to the leaves of vegetation being removed. And my question is, which of those supplies the basis for the violation?
So any vegetation removal less than 3 feet in height, and that would include leaf litter or other natural organic covering of that buffer zone, that area within 100 feet.
Okay. And to state the obvious, it also includes the leafy portion, right?
Yes, absolutely.
Okay. Now, a question for you. How do we know, and what do you base the violation to Big Lake Marine on, that it did this work and removed the vegetation? What do you base that on?
Well, we had a couple of different things. We had a meeting in November of 2021 with Robert Fogg of Q Team, immediately following the first, hold on one second, please. Sorry about that. We had a meeting with Robert Fogg immediately following our October site visit in 2021, where he came in and met with Chris Hansen, my assistant, and myself, and he admitted to doing all of the work as described in their letter from Aaron Goslin on the 18 Fernwood property, and stated that they did no work on the 28 Whitetail lot, and that it was his understanding that that work was done by the excavation contractor that was doing the stabilization portion of the project.
Okay,
We did also
lem-
receive, yep.
Let me just interrupt you. What's your understanding of the work that Q team does? What type of material does it remove?
Yeah, he did actually state in that meeting with us that Q Team is in the tree business. That's their line of work. They remove trees. They don't remove shrubs. They don't typically do anything less than 3 feet in height because that's just not their business.
Okay, and did you find your conversation and what the folks from Q team told you? Did you find that credible?
Yes, I mean they appeared to be honest, transparent, and I had no reason to believe anything otherwise.
Okay, now Attorney Braun provided the board with some text messages. Did you have a chance to review those? Okay, did anything about those change your view that Big Lake Marine did this work at Whitetail?
I just don't feel like those emails really said anything to lead me to believe that Q Team did the work on 28 Whitetail. It's just not clear what lot they're even really talking about. And it just doesn't provide me with enough information to change my mind on
Okay.
that one.
I'm going to show you Exhibit H that was submitted by Attorney Braun. Now, this shows some grass. Now, and I understand that he said that this photo was taken today. Now, does that photo mean that vegetation was not removed in the fall of 2021?
No, it just means that someone replanted grass or grass grew back.
Okay. Okay. Violation number 7. Now, this violation is for clearing or removing vegetation without a permit because the shoreline zoning ordinance prohibits the clearing or removal of vegetation of any height without a permit, and that's in the table of land uses. And for the same reasons that the board upheld this violation as to the other notices of violation, you should uphold it now too. Alex, could I have you walk us through this this violation, please?
Sure.
Here's Exhibit 12.
Yeah, so here in Exhibit D, you can see there's in the before photo, there's natural ground cover, existing ground cover. There's vegetation less than 3 feet in height, and there is a tree next to the stairs. And in the after photo, you can see the grass has been removed or has been covered over, and the tree has been removed that was next to the stairs.
Okay.
Same thing here. There was shrubs, grass growing in the before photo that are no longer in the after photo, and there's actually a large tree that was at the peninsula in the before photo that is no longer.
Okay.
Same thing here, ground cover removed without a permit next to the house. And again, here at the shorefront for the illegal stabilization project.
And for violation 7, it's relating to whether work is done with a permit or without a permit. Was there a permit for this work?
No.
And that's what generated the violation for violation 7.
Correct.
Okay. Now there's a contention that violation 6 and 7 are duplicative. And I just wanted to address that. You should reject this argument. Violation number 6 is for clearing or removal of vegetation under 3 feet or removal of ground cover, such as leaf litter or forest duff layer within 100 feet of the normal high water line. That's just period. That there's nothing about a permit there. Just removal of all those things is prohibited by the shoreline zoning ordinance. Now, violation 7, on the other hand, is for clearing or removing vegetation of any height without a permit from the code enforcement officer. So they're different. Now, at the last meeting, there was some discussion amongst the board about how the violations in 6 and 7, and were they really different or were they combined? In fact, you combined these violations before, and I just wanted to address that. it is possible for a violation and I'm going to refer to these by shorthand by violation 6 and 7. 6 being the removal of vegetation or leaf litter or forest stuff layer or ground cover within 100 feet of the normal high water line. I'm going to call that violation 6. And violation 7, I'm going to use that as shorthand for clearing or removing vegetation without a permit. Now, there are numerous ways you can have something be a violation of 6, but not of 7. So for instance, if leaf litter within 100 feet of the normal high water line is removed, that would be a violation of 6. But because that leaf litter isn't vegetation, it wouldn't be a violation of 7. So the shoreline zoning ordinance defines vegetation as all live trees, shrubs, or other plants. So they have to be alive for it to be vegetation. And leaf litter is not alive, it's dead. So that in that respect, you could have something be a violation of 6, but not of 7. Now, let's assume that there were dead blueberry bushes on a shoreline, or not necessarily within a shoreline, but within 100 feet of the normal high water line. And let's assume that those dead blueberry bushes are removed without a permit. That would violate number 6, because that would be a removal of ground cover. It wouldn't violate number 7 because it wasn't vegetation, because it's dead. Now, on the other side, what could be violations of 7 but not of 6? If you remove any trees or shrubs 110 feet from the normal high water line without a permit, that wouldn't be a violation of 6, but it would be a violation of 7 because you'd be removing vegetation without a permit as prohibited by the table of land uses. Now, another example of that would be a removal of a shrub less than 3 feet in height within 100 feet of the normal high water line to create a footpath. That wouldn't violate number 6 because section 15 QC expressly allows the removal of vegetation less than 3 feet within 100 feet of the normal high water line for the purposes of creating a footpath. But that would violate number 7 because there wasn't a permit for it. And finally, a removal of a 4-foot high shrub without a permit within 100 feet of the normal high water line, that wouldn't violate number 6 because it was greater than 3 feet, but it would violate 7 because there isn't a permit for it. So I just wanted to describe, as in a legal argument that 6 and 7, they're not the same thing. They're different. They shouldn't be combined because you can have violations of both 6. You can have violation that's 6, not of 7, or 7 and not 6. So they're different. I want to move on to violation number 8. Violation 8 is for violating the shoreline zoning ordinance's requirement that a stabilization project require a planning board permit. Now, Alex, the work that was done here by Big Lake that it contends is a stabilization project, was it done with a permit by the planning board? Okay, you're
No.
Okay, thank you.
Yeah.
Now, as described earlier, a structure is anything temporarily or permanently constructed, erected on or in the ground. And for that reason, the constructed shorefront here is a structure. And for purposes of the shoreline zoning ordinance, expansion of a structure means to increase its in footprint or height of a structure. And the ordinance explicitly states that only repairs or renovations that do not involve expansion of the non-conforming structure can be carried out without a permit. So in other words, if a structure is expanded, the ordinance states that the activity is not a repair or renovation that can be done without a permit. So for that reason, a permit was required for this project that Big Lake contends is a shoreline stabilization project. Now, I'm not going to go back to it. I pointed out before the survey that was submitted by Attorney Rachin about a month ago to the board, which was 2 of them, one from December, one from January, clearly stated that the shoreline had been pushed forward. So it's clear that the shoreline has been expanded. I don't want to belabor that and just want to remind the board of that. Violation number 9. Violation 9 is for completing a shorefront stabilization project without a permit and without a barge rather. And for the same reasons you upheld this violation as to management controls, you should uphold it now. The ordinance requires that a stabilization project that must have a permit from the planning board, and that construction equipment must access the shoreline by a barge when feasible, as determined by the planning board. Now, Alex, this was never submitted to the planning board, so we don't know what the planning board determined, but you're authorized to enforce violations of the shoreline zoning ordinance. Is that right?
Correct.
And did you determine that it was feasible for Big Lake to use a barge?
Yes.
Okay. And is your understanding that Big Lake had a barge?
Yes.
Okay. And do you have an understanding that Mr. Durant, what he said about the feasibility of a barge?
Yes, at a site meeting earlier this summer, he did confirm that he would be able to use the barge to access the 28 whitetail lot.
Okay. Violation 10. Big Lake denies it committed this violation because it wasn't hired to perform the work and that it didn't remove the vegetation. Now, Alex, you testified earlier that you understood and you described the basis for your position that Big Lake removed the vegetation. Is that right?
Yeah.
Okay. And this violation, it relates to creating a canopy opening of greater than 250 square feet. Is that right?
Yep.
Can you walk us through that, please?
Yeah. So we obviously weren't able to, inspect these trees before they were removed, like the ordinance requires. So we had to base a lot of this on before photos. So Exhibit F of the NOV shows, the Google aerial imagery of this site prior to the work being done, with measurements established based on the scale provided at that elevation, showing 25 by 60 area, which is greatly exceeds 250 square feet. The large trees to the right where the deck is, there's a large tree that was removed near the stairs. You may remember that one from a few slides ago. That canopy shown here has all been removed by that tree.
Is that this?
Yep. And then on the left-hand side near the boat ramp, the tree that was at the point of the peninsula, shown on a number of slides, has been removed, as well as a couple large trees on the other side of the boat ramp. So the canopy shown here is canopy provided by those trees based on our photos of the site prior to the work taking place.
Okay, thank you, Alex.
Mhm.
Okay. Violation number 11. This violation is based on that part of the shoreline zoning ordinance that allows only selective cutting of trees within a buffer strip, so long as a well-distributed stand of trees and other natural vegetation is maintained. And if other trees are present, that provides sufficient points to allow selective cutting of otherwise healthy trees. For the same reasons that you upheld this violation as a management controls, you should uphold it now as well. Alex, can you walk us through this violation, please?
Yep. So the point system, like I described earlier, you have to establish a 25 by 50 foot grid. If you're looking to selectively remove trees, that's for non-hazard trees, selective removal. Here you can see we laid out a 25 by 60 foot area, again, based on Google aerial imagery scale at the height of the photo taken. And that canopy comes from that one tree, like I had mentioned before, that was removed on the peninsula. If you establish a 25 by 50 foot grid and there's only 2 trees in the grid, you can't remove anything. And that's because you still wouldn't have enough points. Even if they were both 12 inches or greater, that's still only going to be 16 points. You need to have a minimum of 24 points to remove a tree within a 25 by 50 foot grid. You also have to have 5 saplings, which are trees less than 2.5 inches in diameter at 4.5 feet, in order to remove excess.
Thank you very much. Okay, the last violation is violation number 12, and it's for removal of vegetation without a permit, and this relates to vegetation that's between the house and the water. So this would include vegetation beyond the 100-foot normal high water line. Is that right, Alex?
Yes.
Okay. Could you walk us through this violation, please?
Yep. So going to Exhibit F, you can see there is, you know, a number of large trees that have been removed. Looks like 11 here. And looking at, sorry, hold on, I'm pulling that. Lost my screen here. And then on this side, you have 10, 11, 12, 13, and 14 on the other side. There's another photo showing 11, 12, and 13 from the archived, or not archived, but the historical Portland Water District imagery.
Okay.
And number 14 on the other side, which was the tree I used in the example for the point grid, where it's the only tree in that segment of shoreline.
Okay.
Here's another angle, another Portland Water District photo of 1 through 10.
Okay. And, you know, to the members of the board, for the same reason you upheld this violation as to management controls, you should uphold it now as well. Now, the last argument that's made on appeal by Big Lake is that it performed the work it performed met the requirements for permit by rule under the DEP's rules, and that it complied with the shoreline zoning provisions. First, Alex, did the work comply with the shoreline zoning ordinance provisions?
No.
And then I'm not gonna belabor this. The DEP, they issued the violation before. We provided that to you before, and that's the other basis for this. That it did not comply with the permit by rule. And with that, I don't have anything else. I'm gonna stop sharing my screen.
Any questions by the board to either Attorney Wyckoff or Code Enforcement Officer Soray?
Oh, go ahead, Greg.
No, I was going to make a quick request at some point, just get it on the radar. Is there an opportunity in the near future if we could make a quick recess? Happy to wait. Doesn't have to be right now, but I just want to put it out there. Whenever we think the most opportune time in the foreseeable future would be.
I share your desire. I'm hoping we can get to the end of the public hearing pretty quickly.
Fair enough. I do have a couple of questions if I could address those now as well.
Yes.
Greg.
Yeah. Okay. So I think you probably, Alex, this is for you. I think you probably know where this is going. But can you show in the exhibits, and I appreciate the precision that we've delineated on 6 and 7, but can you've referenced exhibit F and D, or I believe, yeah, D and D for those two extensively. Can you show an example? Because it's one thing that now that we can define them in abstract, that they can be logically violated. Now, can you demonstrate where they are? Where was the leaf litter removed that would uniquely violate 6? And then Attorney Wyckoff, I don't know if I got your enumerated examples of 7 quite as well. I know one of them was an example of a exclusion allowed by a footpath, but if we could basically do that exercise for both, so I could basically take the argument that Attorney Wyckoff has made and tie it more closely to the evidence. So that's a question for Alex, but be on deck for the, because I only wrote down one of your numerous examples for violation 7 where it could be unique from 6. So I just wanted to give you a heads up.
Yeah, I'm just going through trying to find what would be the best example of that. So there's two it's often called two things, leaf litter or duff layer. And that layer of material is basically all the stuff that's dead and fallen onto the ground, because no surprise, it's actually a pretty good natural filter for runoff as water goes downhill into a body water. So that can be things like sticks, leaves, packed pine needles, for example, is another one that's pretty common actually on Sebago Lake because you have a lot of pine trees. So I think you can find examples of that in a few different spots. I think more common than leaf litter on this site would be the packed pine needles. In some of the before photos, you can see that there was an abundance of that existed on the site. And I can share the, so you can see here, the orange color along this section here. You can see, as I zoom in, it's going to be harder, but you can see the orange coloring of the pine needles in spots on this side as well, down in here. So that's a natural duff layer, a buffer that provides a filtration to the the runoff as it runs down into the lake. See if I can find something different.
But that would not, but sorry to interrupt you, just to clarify, that would not be that would not qualify as a footpath. I guess maybe that's a follow-up question, but.
So, I mean,
So that can't be removed. Oh, sorry, go ahead, Eric.
I should say, I think that's a legal question. I think that's a legal issue there that you're raising. So the needles are dead. They're not vegetation. So they don't need a permit to remove that. But because they're within 100 feet of the line, the shoreline, you can't remove it because it's prohibited.
Right, so it's not considered vegetation.
Right, okay.
But it is falls under that category of the less than 3 feet in height, because it's protected. Is as that buffer. That language in the ordinance is the buffer zone language.
And then
So the pine needles that have fallen on the ground, you're saying apply to this ordinance?
Yes.
See, okay.
Are you saying, Alex, that's the forest duff layer?
Yes.
Do you know if leaf litter is defined?
It is not, as far as I'm aware.
And is forest duff layer defined?
That might be.
it's not.
No. No.
Okay. And then my second part was on the examples that were given for 7. If you could point out the, I believe these are more straightforward, but just which specifically of the vegetation less than 3 feet without a permit, or I assume that's the grass and everything else you're falling underneath? Number 7.
Yes.
Okay. If I could too. So number 7, for instance, may I share my screen?
Yes.
Okay. Okay. So this big tree right here by the stairs, that is, it's more than 3 feet in height.
Mm-hmm.
So it could be removed without being a number 6, but you have to have a permit to remove it. And there was no permit, so it's a 7.
Right, but that's a great segue to my third question, which was, about violation number 12, which I thought when I interpret number 12, you would point to that tree and say that's like a violation of number 7. So now I'm on to a question of how do we differentiate between 7 and 12, and the fact that you brought up a tree, which is kind of what I thought we were talking about, makes me think that when I addressed this last time, makes me think that it would be helpful if you could point to examples that uniquely violate 6 and 12 or 7 and 12. Sorry.
Sure. So in the notice of violation, number 7 relates to the removal of trees and vegetation within 100 feet of the normal high water line. Number 12 relates to the removal of vegetation that could be beyond that. It's between the house and the water by its terms. So there could, in other words, it could be a distance issue between the normal high water line and the location of the tree or the vegetation.
Okay. Well, aren't they referencing the same ordinance?
That's true. I mean, if you think about it, there could be a violation for each and every individual tree that was removed, right? So there's 14 trees that were, at least 14 trees that were cut down. Each one of those could have been a separate violation.
Well, I think
the temporal limitation, the distance actually matters.
Sure. I'm just trying to understand specifically what ordinances were violated and whether or not the evidence substantiates those. The magnitude of the violation, the number of trees, I think are kind of a secondary thing. So that's why I was asking for clarification. So
to your point, I'll answer your question directly. 7 and 12, they rely on the same ordinance provision. You're right.
Okay, thank you. That's it. I'm good.
Anyone else with questions? Okay.
I'm all set.
Attorney Wagner, what was the next step in this?
I would give an opportunity to Attorney Braun to ask any follow-up questions, but with the request that it not retread on territory. To the best that you can do that.
No, I will certainly make that a primary purpose. I just have to, I'll note that we did just have an entire recitation of a presentation that's been previously provided to this board.
Fair point.
Alex, you mentioned that part of the reason why you were inclined to believe Q Team as it related to the services they provided at Whitetail was given your experience, and I quote you, I think, that they were known to submit multiple permits at a time for multiple jobs. Is that correct?
Yes.
Okay.
Somewhat. I would say
somewhat.
Yes, I'll say yes. I think that's
all right.
Probably.
But in fact, this board has already established and found that they failed to apply for or obtain permits related to the adjacent property, correct?
Well, according to them, Rob Durant failed to, because they were under the impression that he was obtaining their permits, is what we were told.
You also testified, though, that was uncommon or unusual for someone like Q Team to rely upon a third party to do that and make those applications.
Correct. Q Team typically, from my experience, has always applied for their own permits. This is the only time they have not.
Okay. The other question I have is as it relates to the 2 pages of handwritten notes that were provided by Attorney Wyckoff. You stated that you had additional evidence related to measurements or record keeping. Is that correct?
No, all I was saying there is we have 2 files for this property. We have a paper file and an electronic file. All of the documents that have been generated and transmitted electronically are in our electronic file. But we do also have some things in the paper file, and that is basically just handwritten notes that Chris has taken. I don't typically keep any handwritten notes. I usually do everything, electronic.
Sure. Electronic or handwritten, do any other measurements or records related to your investigation of the property exist other than what has been presented here to the board?
I mean, we have a pretty large file, so yeah.
Okay, so we would find in your records other documents related to the measurements taken by you or your office?
As far as measurements go, no, I think this is probably I would say probably the only document. The only other thing the reason I'm kind of cautious about saying that is there's probably some emails, like for example, DEP had sent us, a summary of an inspection summary with some measurements included, which that's an electronic document, not something that's paper. But that's probably, I would say, it between those two things. Yeah.
All right, I have no additional questions.
Thank you. Attorney Rachel, anything?
Yes, I'm sorry, it's not so much a question, but I did want to address the issue around what we believe is duplication of 6, 7, and 12. I don't know, this is more in the nature of argument, so I'm not sure if this is the time, and I'm happy to wait, but.
Yeah, why don't we just wait? We'll open it up in the public hearing and you can offer an additional comment then.
Thank you.
Attorney Wyckoff, there'll be an opportunity after the public hearing if you want to make any responsive arguments, but I don't know if you have any additional questions for Alex.
No.
Okay.
Can I just say one more thing before I guess our time is done?
Sure.
Since this is coming to the end of this portion of the process, I just want to thank all the board members. I want to thank you, Stephen, sorry, and all the other attorneys. I know this was a bear of a process, but I think it went as well as it could. So thanks, everyone.
Thank you, Alex.
Thank you, Alex.
Thanks.
So I would suggest to the board that we do a motion to open up the public hearing, see if there are any comments from the public, and that would be the time to hear from Attorney Rachel, and then close the public hearing.
Very good. I will motion to open public hearing. Can I get a second?
Seconded.
Any questions before we move on to that? All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Ian Lockwood, yes.
All right, so opening us up to public comment. Is there anyone here from the public tonight that would like to speak in favor of this application? Anyone here in the public tonight that would like to speak in opposition to this application? And finally, is there anybody here tonight that would like to speak from a neutral perspective in regards to this application? All right, seeing and hearing, we will close public comments.
And then I would give Attorney Rachel an opportunity. She had some additional arguments.
Thank you. Really, it's not so much additional, but just to repeat and highlight again, and not to belabor, because I know we've all been here for a long time and heard all the arguments. But I would just urge the board to uphold your decision from the previous finding fact you just adopted with respect to management controls appeal. With respect to violations 6 and 7 being duplicative, and also, as Attorney Wyckoff indicated, that and I think it was in answer to Member Dean's questions, that 7 and 12 rely on the exact same provision, and it's relating to vegetation. And for the reasons that we've been arguing all along the way, is that is truly duplicative. And that really is not separate violations. And I just wanted to highlight, I think I think it was Attorney Wyckoff who had said that, you know, hey, we could issue violations, individual violations for each and every tree. And again, that's about magnitude. It's not about separate violations. And I think that that comment kind of underscores what is happening here. It's just this notion that there, for every single thing that should be included under the auspices of one type of violation. We're trying to segment and target violations for things that really are not separate and distinct. And for that reason, we're just urging this board to uphold their decision that 6 and 7 in fact are duplicative, and also that 12 again relies entirely on the same ordinance provision, and just please take that into consideration. Thank you.
Very good. Thank you.
So I would give the town any final arguments or comments, and then end with Attorney Braun having the last say as the appellant.
Thank you very much. First of all, let me just echo what Alex said. Thanks all to you for hanging in there. This has been a long process, and I'm sure there are other things you'd rather be doing with your time than this, but I just want to acknowledge that this has been an effort and a heavy lift for all of you, and you may not have signed up for this kind of a thing, but you know, thank you for doing your duty. It's important the way we do things in our state, and it's important. I just want to acknowledge that and thank you for all of that. So here, the only testimony we heard tonight was from Alex Soroy, the code enforcement officer. The applicant didn't provide any testimony from any other witnesses, just Alex. There are some documents that provided. None of them change anything at all. They really don't relate to the issues at hand, and to the extent they do, they don't move the needle one bit. You should uphold all of these violations except for violation 5, which the town isn't pursuing anymore. And you should uphold those for all the reasons that you upheld these violations in the past. And you should uphold them based on the factual record here before you, based on Alex's testimony, based on the documentary evidence that's been provided to you, and based on the legal arguments that have been presented to you. Let me focus for a moment on violations 6, 7, and 12. 6 and 7 are different for the reasons that we described earlier. They're separate and distinct, and they can be separate violations. They don't rely on one another. They're very different. 12 is different than them as well. So for instance, 7 and 12. Violation 7 relates to the removal of vegetation within 100 feet of the normal high water line. That's what it says on its face. Violation 12 relates to removal of vegetation with 100 feet of the normal high water line. And then also beyond, it relates to the vegetation that's between the house and the water. It's true that those rely on the same provisions in the ordinance, but they rely on different facts. Facts actually matter. There could be violations issued for each separate tree, and those would be violations that would be appropriate and that would be able to be upheld under the facts and the ordinance. So 6, 7, 12 are all they're unique violations, and they're different, and they should all be upheld. So for all of these reasons, the town that requests that you uphold all of the violations that the town is pursuing in this matter. Thank you.
Thank you.
Braun?
Attorney Braun?
Sure. So, I mean, I guess first I should join in the rounding thanks, to the board. Certainly none of us wish and would want to be here. I know you all have volunteered for this. It is a volunteer position. Some might think that the job or the purpose of the board is merely to uphold what the code enforcement officer is determined to be violations. I would hope all of you recognize that's not your role, but rather it's to determine whether or not the provisions and ordinances of the town have been appropriately and lawfully enforced. And I would say that Attorney Wyckoff is right. Facts matter here. In what way? We're arguing that for every single tree that's been cut, that on its own could be an individual violation. I mean, same logic here would apply that for every 10 cubic yards of soil that was moved, that could be a violation. We would do the same for every square foot potentially of shoreland, if you are to believe that that is in fact a structure. And facts matter. And again, what I come back to here, my frustration on behalf of my client is the very poor record keeping and the very poor investigation that was done when this process was commenced. We heard Alex testify or state before you repeatedly that he used an iPhone. He had a toolkit. He didn't generally pull those tools out. It seems again and again that we're told and that the board is left to just believe and go along with the argument that the thing speaks for itself. And that's unfair. And that really isn't the process and the purpose of this proceeding, especially when you consider something like an active and changing environment like a shorefront. The water goes up and down, right? Ice comes in and out, moves these things. And without those explicit and specific measurements and intended documentary procedures, what we're left with are allegations and pictures that say, look, here, see, that's it. And that's frustratingly and truthfully not sufficient for these purposes. And where Attorney Wyckoff here is, suggesting, at least in part, that you should now tonight rule that 6 and 7 should not be put together and combined, and that 12 also should be upheld. Really, that's an advocation that you should change and rule on something other than what you just previously did. And again, so facts and these processes matter. I don't know how we can say that a process and a system where very little effort was taken to actually establish the qualifiers and measurements necessary in these allegations, and where the town's attorney is suggesting that you should now find something more punitive or more significant than what you just ruled on with these same fact patterns is fair or equitable. Similarly, to that point, facts matter, words matter, right? Repeatedly in this, okay? We look at these provisions, we look at these violations, and what do we see? We see, broad characterizations of things that just aren't true, right? For example, all existing vegetation, right? We know that's not true, where they repeatedly indicate that all vegetation in certain situations or certain areas of this project were removed. That's not the case. We know that root systems were left intact. Where it speaks to areas, square footage, we're told to rely on Google Maps that explicitly and within them have flaws, right? Where distinctions or indicators for property lines used for tax purposes are wrong and admitted to be wrong by Alex Saroy. As it relates to the barge, we're told to essentially disregard the clear language of it. It doesn't talk about, where you do the work from. It talks about how you get your equipment there. And yet here, we're being alleged to have committed violations because we didn't do it from the equipment sitting on a barge, but rather had the equipment on the ground, from the land. I mean, the words matter here, and the way that they're characterized do matter. And so for all of these reasons, I think that the violations are ineffective. The evidence that the town is presented here is insufficient to uphold them. And certainly, as it relates to these trees, subject property, I think that this is absolutely an area and a violation that the board should determine Mr. Durant and Big Lake Marine were not responsible for. Those emails clearly discuss multiple properties, adjacent properties on the shore line. And I would also refer you back to the contract by and between Mr. Durant, Big Lake Marine, and Robert Boudreau, the owner of these properties, that indicates in it exactly what work is to be performed. And in nowhere in any of those contracts, which you've previously seen and previously been entered in these hearings, does it say that Rob Durant or Big Lake Marine or Durant Construction are being hired to do that work. At most, what it indicates is that dead trees are to be cleared or removed as part of the broader project. And so for all of these reasons, right, and not even to mention and get into, again, the duplicity, the repeated nature of these violations, this board should dismiss the violation, should uphold our appeal. And with that, I thank you for your time.
Good, thank you. So we're at 9:07. It is a good time to take a break. About a 10-minute break, come back at 9:17.
We do a quick motion to close the record.
Yeah, can I get, so moved. Can I get a second?
Second.
Sorry, question from Attorney Rachel.
Yes, I'm sorry. I think it's abundantly clear, but you know, we attorneys like clarity. I just want to make sure that we all agree when you close the record, that record that is being closed applies to each and every, I think we all agreed, and it's in the, I see Attorney Braun nodding. I'm hoping Attorney Wyckoff agrees that basically the record produced today is part and parcel of all the other appeals, and the arguments and the record that was made apply to each and every appeal. I just want to make sure that's on the record, and I believe that's entirely consistent with how we've been dealing with this all along, but just want to make sure.
Were these not
Yes.
cumulative, Attorney Wagner?
Attorney Wyckoff, do you agree?
Yes.
Okay, I agree. I think the only
I mean, we've been,
slight
just to
issue
be
I
clear,
think is you
we,
might
we,
have. Sorry, go ahead.
I was just gonna say, I mean, I think that's been the agreement we've had since the beginning.
Yeah, I think that is. I think the only thing where maybe it's a little bit weird is the last appeal, we excluded one piece of evidence of from Attorney Braun. I think the emails were not part of that. And I think that remains the case for that appeal. So I think that's the only qualification I would have on what Attorney Rachel said. Otherwise, yes, the record is applicable to all the appeals. So there's a motion on the floor to close the record.
Yeah. So all those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Got it. You're on mute there, Fred.
Fred Miller, yes.
Pete Lockwood, yes.
Very good. So now we're at 9:10. I still propose 10 minutes. How about we come back at 9:20?
Sounds
Okay.
good.
Thank you. So zoning board of appeals is back from break. Attorney Wagner, if you could, as you have in the past, sort of guide us through next steps.
Sure. So board will now proceed to deliberations. As before, I suggest that we go through each of the issues raised in the notice of violation, or rather in the notice of appeal, taking them in turn, and take votes on the conclusions. Like before, you know, I'll have you go through, identify the violation, the sections of the ordinance at issue, make your factual findings. Where I think it's appropriate, I'll flag some of the issues that have been raised by the parties that I think the board should consider and address. And once I get a sense of the board's factual findings, I'll suggest that you, or chair, doesn't have to be me, can suggest a motion, or anybody can suggest a motion to ultimately uphold the violation at issue, or to deny the appeal in part on that issue, or to grant it on that particular issue. So, as before, I've got before me the notice of violation, the notice of appeal, and because I find them useful, the proposed findings of fact and conclusions of law prepared by the town. And that's what I'll be using to guide me through this. So I would turn it over to the chair. I have in my notes that the first issue here is whether violation 1 should be vacated.
Yeah, so violation 1, filling and earth moving of more than 10 cubic yards, referring to shoreline zoning provisions, section 15, subsection U11, You know, having looked at this, the ordinance clearly states, permit shall be developed in accordance with an erosion and sedimentation control plan prepared in conformance with the requirements of the Maine Erosion BMPS, Bureau of Land Water Quality, Maine Department of Environmental Protection. So I don't believe a permit was obtained. Also, all activities which result in unstabilized soil conditions will require permits. I heard what Attorney Braun indicated with regards to what was potentially unstabilized or not, but these are activities from what was presented clearly show that it was unstabilized soil conditions. So I believe there's sufficient there to uphold the violation. But board, do you have any comments you want to have included?
This also has the 10 cubic yards in it too, right? More than 10 cubic yards of fill and earth moving occurred.
Yeah, that's a
And
component.
therefore, they need a permit from the CEO, which was required by,
Well, that one, yeah, that one's number 2.
that's violation 1, I think.
No,
Violation 1 is the sediment control.
yeah. It says filling and earth moving of more than 10 cubic yards, Fred, but it's focusing in on the
Okay.
what
Earth moving.
Greg indicated.
Okay.
I believe I have one additional thought to add to this that might be
Sure.
helpful. In the finding of facts here, I think that one of the substantive arguments was that there was not a disturbance, and I think that they referenced the growth that there was there now, and I think that it's important to point out my interpretation of the evidence as it was presented is that just because it's grown back doesn't mean the violation didn't occur. So I found it quite compelling that a lot of time has passed. So with respect to the new growth and the argument that soil disturbance didn't take place because growth was found now, I think is kind of is a pretty weak argument. So I wanted to just point that was considered as it was argued, but I don't think it's compelling.
I agree with Greg.
Yeah, thank you, Greg. I would agree as well. So motion to, you're gonna have to help me out with this first one.
Yeah, so just, can I also confirm that based on those findings, you would agree that the ordinance provision cited 15U1 was violated?
Yes.
So I would then suggest a motion to uphold violation 1 based on those findings.
So moved. Oh, I'll second then. Do we have any further discussion, board? So voting on this, voting in favor to uphold, David Murch.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lee Lockwood, yes.
Okay, it's unanimous. Moving on to the second issue I have here, which is whether violation 2 should be vacated. Turn over to the chair.
Yeah, so for this one, we have, well, a second here. I have a question, Attorney Wagner. It says the violation 2, they're arguing that violation 2 is a duplicative of violation 1. Is that what we're discussing right now?
So it, in my way of looking at it and how I think we've approached this in the past, I'll have one section of the decision that addresses violation 2, and I think there are 2 arguments in there, very broadly speaking, two arguments. One is that two should be vacated on the basis that it's duplicative of one. So we should address that. And then the second issue is more broadly that the evidence does not support a finding that the violations alleged occurred.
Okay, very good. Yeah, so filling earth moving of more than 10 cubic yards without a permit. Ordinance reference shoreline zoning provisions, section 14, table of land uses, number 30, filling and earth moving of more than 10 cubic yards. So in terms of specifically that, I believe the evidence indicates that earth moving of more than 10 cubic yards was done. And also this is a specific to earth moving, whereas violation 1 was more in reference to having the erosion control. So I don't find it to be duplicative. Anyone?
I agree with you, Dave. I believe that, like you said, number one is more for the preventive of the erosion and sediment of the surface water, and that second one is of moving of the actual material. I don't believe they're duplicates, and I believe it was definitely more than 10 yards moved.
I would agree with that also, David.
I believe the evidence that was shown too, that I believe that there was more than 10 yards moved. I know we had a lot of discussion about, you know, how it was measured and whatnot, but I believe that what Alex gave us in the presentation that we had, that it was evidence definitely showed that there was more than 10 yards that was moved.
Yeah, the riprap, the bank was regraded. There was mulch and spanning exhibits E, C, and D. I think it's pretty substantially clear it's more than 10 yards without any reasonable error that you would bake into the measuring devices that were used.
Can I ask, would the board agree that for the same reasons and factual findings, that it applied to a pole violation 2 as it pertained to 28 whitetail management controls would apply here as well, such that I can reference them by incorporation in our decision?
Yes, I would say yes.
Yep, perfect.
Okay. So that's all sufficiently clear to me. Based on those findings, would the board conclude that Big Lake Marine violated shoreline zoning ordinance section 14, line 30?
Yes. Yep.
Okay, then I would suggest a motion that the board denies the appeal on this ground and upholds violation 2.
So moved.
Seconded. All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, that's unanimous. Moving to the third issue I have here is violation 3 alleges that violation 3 should be vacated. So I'll turn it over to the chair.
So piers, docks, wharves, bridges, boat launches, and other structures and uses extending above or below the normal high water line or within a wetland without a permit from the planning board, and this is specific to the boat launch. Referencing shoreline zoning provisions, section 14, table of land uses, item number 17B, permanent piers, docks, wharves, bridges, boat launches, and other structures or uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, LRR2 districts. Referencing to a boat launch, which has, I believe, evidence of being expanded, non-conforming structure. Yeah, I I feel it fits. I do see that this is a violation, given the information provided
I agree,
by the
Dave.
town.
Agreed. Yeah, I think the logic that was laid out was it was a non-conforming structure. Expansion requires approval. It was expanded in almost all directions as far as you can tell from Exhibit B.
I mean, it actually goes straight across now instead of
Yep.
having the jog, so.
No evidence of a permit. So
Correct, no permit. I believe it was estimated like 15 feet wide now, approximately.
anyone else?
I might echo as well in terms of the previous findings on this same violation, that they also stand for the reasoning. If that's helpful. I don't know if that's the time to bring that up now or not, but just kind of.
Yeah, that's clear to me. Does the rest of the board agree?
I do, yes.
Yes, I agree.
So therefore, does the board conclude that the evidence establishes Big Lake Marine violated the shoreline zoning ordinance sections cited in violation 3?
Yes.
Yes.
Yep.
Yes.
Yes.
So I would suggest a motion that based on those findings and conclusions, the board denies the appeal on this ground and upholds violation 3.
So moved.
I'll second that.
Second.
All those in favor, David Murch, yes.
And Melly, yes.
Tom Hennessy, yes.
Pete Lockwood, yes.
Did we get something from you, Greg Dean?
Sorry, I'm having technical difficulties over here. Greg Dean, yes.
Thank you.
So fourth issue I have here is whether violation 4 should be vacated.
Number 4, piers, docks, wharves, bridges, boat launches, and other structures and uses extending above or below the normal high water line or within a wetland without a permit from the planning board. This is specific to the shoreline. Again, referencing the exact same shoreline zoning provision. We've heard definition by the town with regards to what a structure is, how that shoreline fits into that. I think they made a good presentation with regards to the shoreline being a structure, and I do see that it's been extended. So I would believe this one to be upheld.
I agree, Dave. I think
I agree also, Dave.
Yep.
Would the board also agree that its factual findings and conclusions and reasoning from violation 4 of whitetail 28 whitetail management controls would apply here as well as it pertains to Big Lake Marine?
Yes.
Yep.
Yes.
Yes.
Yeah, okay. And so based on those findings, would the board conclude that the evidence establishes Big Lake Marine violated the shoreline zoning ordinance provisions cited in violation 4?
Yes.
Yes.
Okay. So I would suggest a motion that based on these findings, the board denies the appeal on this ground and upholds violation 4.
So moved.
Second,
All those in favor, David Birch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lee Lockwood, yes.
Okay, the 5th issue is whether violation 5 should be vacated. The town has withdrawn violation 5. Before, in this situation, the board has still taken up the issue and for that reason deems it vacated. So I would suggest a motion to vacate violation 5.
So moved.
Seconded.
David Birch, yes.
Fred Miller, yes.
Greg Dean,
Tom
yes.
Hennessy, yes.
Lee Lockwood, yes.
Okay, that's unanimous. The next issue is whether violation 6 should be vacated.
Number 6, removal of vegetation less than 3 feet in height. I'm gonna read this one in full. All existing vegetation less than 3 feet in height, including shrubs and ground cover, has been removed within 100 feet of the normal high water line of Sebago Lake for a majority of the lot's shorefront. Remove vegetation was stabilizing this segment of the shoreline and protecting water quality. Referencing shoreline zoning provisions, section 15 of the land use standards, subsection Q, clearing and removal of vegetation activities other than timber harvesting. Further subsection C, in order to protect water quality and wildlife habitat, existing vegetation of under 3 feet in height or other ground cover, including leaf litter and forest duff layer, shall not be cut, covered, or removed except to provide for a footpath or other permitted uses as described in section 15Q, paragraphs 2 and 2A above. I know that with regards to number 6, Attorney Braun has indicated that Big Lake was not hired to perform the work alleged in said violation and in fact did not commit the alleged conduct. I did take some time and review essentially the contract, or at least the invoicing for Big Lake Marine with regards to this property, and it does indicate that they would, says any and all dead wood would be cut up and removed from the project location as DEP allows. So in regards to that and the visual evidence we were provided, I will say I didn't see any indication of any dead wood. And I do believe that would fall under this particular provision of any ground cover. And that would include leaf litter and forest stuff, but that's not exclusive to it. Should not be cut, covered, or removed. So I don't know. I believe this is a violation, given the evidence provided.
I believe it's a violation.
I agree.
I think I'm struggling with the kind of newly articulated differentiation between 6 and 7 in my mind. And I know we voted to, I don't know if it's appropriate. I kind of think that these 6, 7, and 12 sort of warrant a kind of discussion that addresses kind of multiple points, if that's okay. And I specifically asked very pointedly from the evidence, point to what the violation of 6 is that differentiates it from 7. I want to just everybody to focus on what the answer to that question was. It was a little bit of pine needles, and then I followed up and asked if there was a definition of leaf litter or a definition of forest duff layer, of which there is not. I have a hard time either 6 is fully subsumed by 7, or it's separated by this leaf litter and forest duff layer. I have a hard time believing that what was presented as evidence is the definition of leaf litter or forest duff layer. And then no one would be able to rake their lawn or remove pine needles or anything. It would be comically bad interpretation of the ordinance. I feel very strongly that this is either a duplicate to 7 or not a violation.
Can I tune in onto that, Dave?
Oh, of course. Yep.
So I'm looking at it a little bit different than you are, Greg, is that I read this as that this includes everything that's 3 feet high or less, not just pine needles on the ground or not just leaves. We're talking about any vegetation, which obviously, if you look in these pictures, there's obviously vegetation there that's less than 3 feet tall. So I feel that in number 6, why I feel it should be upheld is because of, we're not talking about pine needles, we're talking about everything that's under 3 feet. And then when you go over to violation 7, which is where now we're talking about stuff that's over 3 feet. So I mean, that's why, you know, I feel it's a violation. I feel it's a violation because it's not just talking about raking the leaves or raking the pine needles. It's talking about whatever they have there that's alive and green, and it's removed or dead.
This is Tom. I fully agree with you, Fred. That they're two separate things.
But the only evidence that made them separate, all I'm pointing out is I agree with you, they are separate things. But the only thing that was pointed out that makes them separate from the town was pine needles. So really this kind of, in my mind, degrades like they are separate, but then if that's the case, then it degrades to, are those pine needles a violation of 6? And so I feel like you kind of come to a similar conclusion, maybe from a different approach, but this has always been, I've always struggled with this in the sense that there isn't, if you can't point to the thing that was the violation, then it's probably not a violation. And those pine needles don't seem like a violation to me. And this is like the 4th time we've been over it, the 4th time I brought it up, and this is the best example they've given of this violation, are pine needles.
Yeah, I tend to agree with you, Greg. Alex did indicate that there was, you know, likelihood of dead wood there, you know, branches and branches and stuff. So, you know, I'm looking at this slightly different in terms of what management control said they would do in the terms of removal of dead wood, which would fall under the ground cover. I look at number 7 a little different, not so much from the duplicative, but personally, for number 7, they're indicating that they didn't, Big Lake is indicating they didn't do the work or were hired to do it. And I don't believe the town has provided, at least to me, sufficient evidence to indicate that Big Lake Marine did indeed do it. They're taking the word of Q team, which I understand, but they're also not providing any evidence that Big Lake Marine did the work. So I'm more inclined to vacate 7 on the fact that I don't see evidence indicating that it was a particular, you know, them that did it. But I follow your logic, and if I didn't have this other thing that I've been thinking about, I would agree with you. So
I don't want to interrupt the flow because this is a good conversation, but just one minor legal clarification. Just remember that the burden of production and persuasion here is on the appellant. So that would be Big Lake Marine.
Yeah, I think you could vacate 6 and uphold 7, or vacate 6 and vacate 7 if that's what you felt. But at this point, given the new conversation that we had around the duplicative nature, which we already found duplicative, we have to address the real argument that's been made that was supposed to make them not duplicative is leaf litter or pine needles. And I just have a hard time getting there when it's like that's the smoking gun. You know, I can't imagine as a resident like that standard being applied to everybody would be like tragic.
But if you look at the picture with the dock or the, I guess a dock area, whatever you call it, with tree 14, I mean, that's definitely got all kinds of growth there and it's all gone. So, I mean, you know, that we're not talking leaves there, we're talking actual growth.
I don't even think that the town debates that. Again, given I asked specifically, what is the violation of 6 that is not a violation of 7? And the answer was the pine needles or leaves or whatever you, I don't see anything in there that to me looks like, you know, you've cleared what was a forest ground, you know, like maybe substantial amounts of leaves and fallen branches, and you've taken something that used to be one habitat and turned it into just barren ground. Like these are, you know, either you've removed grass and you're and vegetation under 3 feet and you're in violation of 7, or these pine needles all of a sudden are in that new violation. I don't know. I mean, I don't really have much more to add. Obviously you can tell I feel strong about it, but I don't want to keep, you know, arguing for the sake of it. But it's just very inconsistent to find that 6 and 7 are duplicative, and then come meet again, and the new information that's presented to us to make them not duplicative is pine needles. That's a pretty low bar of a violation in my mind.
I think the other point I heard was that one is within the 100 feet of the normal high water line, and the other one can be anywhere on the property.
I think that's 7 and 12.
That's 12.
Yeah.
Pete, can I put you on the spot? Because I think you were the deciding vote in the last one on the consolidation issue.
Was that addressed to me?
Yeah. So I think if you recall last time on 28 Whitetail Management Controls, the vote was 3-2 in favor of consolidating 6 and 7. And I believe it was David, Greg, and you, Pete. And I don't think we've heard from you yet on this consolidation issue in light of the additional arguments tonight. So I'd be curious about your thoughts.
Sure. Yeah, no, my thoughts are that they're not duplicative. I think there's been enough information provided to us that we can see a difference between each of these 3 violations. And then I would also add, I think it was just kind of a convenient snapshot where they showed us the pine needles that were located there. But I would also take into consideration all of the shoreland around the boat ramp where clearly they cut the trees and whatever was the vegetation underneath those trees and just completely cleared it out. So I don't think that's quite as obvious, maybe because it's like total removal. But I think that clearly shows that there was total disruption. I'm you know, being familiar with the woods and owning lake property, I can see that type of vegetation or that leaf duff or pine needles is going to be a lot harder to see when it's buried in amongst the woods.
And so, Pete, did I get that right, though, that you were last time in the majority in favor of consolidation?
I don't think so.
Okay, maybe. So was that?
I thought I had the same recollection as well, Attorney Wagner, but.
I'm looking at, this is Tom, I'm looking at the notes. The 3 yeses were David, Greg, and Pete.
I would say with regards to this one, given the additional information that was provided, especially in terms of talking about looking at the ordinance, and it says for section 15 QC, it talks about removal of existing vegetation under 3 feet in height and other ground cover. And in Alex's write-up, he does talk about ground cover as well. And I have to say, I believe ground cover was removed. So I'm tempted to change, be inclined to uphold this because I believe ground cover was removed. So.
And by saying inclined to uphold this, you mean now inclined to treat them as separate violations because of?
Yeah, yeah,
Okay.
yes.
So why don't we can I ask that someone make a motion to, so remind me, we're on 6 here. So how about a motion to consolidate 6 and 7? And again, by making the motion or seconding, you're just queuing it up for a discussion and vote.
Yeah, so moved.
Second.
Okay, any further discussion on this consolidation issue as it pertains to 6 and 7 of this appeal?
So we're combining, I think I had the same question last time. So we're combining them as only one violation?
So the motion on the table is to consolidate 6 and 7 into one violation, yes. And then if that were to pass, just like last time, you would then address the substantive portions of that to find if it supports the claimed violation. So a yes vote is in favor of consolidating 6 and 7. A no vote would say that they are separate violations and should be addressed as such. And that no vote would be a departure from the board's last decision.
We had 2 no's and 3 yeses from the last one, right?
That's right. And so depending on the way this goes, I'm gonna, I may suggest some next steps that impact the prior decision. So, but let's take a vote on this now.
While we're still in discussion on this, I just want to clarify, my point is not that they should, I'm actually recommending that they do not get combined and that 6 and 7 are unique, but 6 actually isn't a violation.
Okay.
I don't know if that's possible, but based off from what was presented, either they're duplicative or it was not a violation. So when you break it down the way I think you're breaking it down, I think my argument might it might be irretractable for me and maybe that's your intent. That's fine. I just wanted to point that out.
No, my intent's actually not to pigeonhole you. It's just I want to address this as cleanly as we can. So I think if we address the consolidation issue first, that'll help me guide us. And so if we say they should not be consolidated, I'm going to have us revisit that prior decision, or I'm going to suggest that the board revisit its prior decision on that point. And then we would need to then go forward and on this, then deal with 6 substantively. And that's when you can make that argument again. And then we would deal with 7 substantively. And if the board does, in regards to the management controls decision, decide to reconsider it, we would do that same process there. So that brings me back to motion on the table being to, on this appeal, a motion to consolidate 6 and 7, just like we did in the last decision.
Okay, I got it. Do we have a motion out there, or does somebody need to make that motion?
I believe there's a motion and a second.
Okay.
That's been, yep. So I'm going to vote no. I do not want them consolidated.
Craig Miller, no.
Tom Hennessy, no.
Pete Lockwood, no.
So is that a unanimous no, or was that a yes from Greg?
I voted yes.
Okay. So we have a 1-4 decision, right?
Yeah.
Okay. So let me make some notes so I don't screw this up. 1-4 to consolidate. Okay, so the next step I suggest then is that on this appeal, we take up 6 and then we take up 7. And then I want to take a pause on this and suggest reconsidering this issue of 6 and 7 consolidation as it pertains to 28 whitetail management controls.
Yeah, I'm just to clarify. So now basically the thought, like, they're not going to be consolidated. So now we vote as if they're separate entirely.
Yep, in this appeal, we're gonna treat them one by one, so.
Okay.
On violation 6, so again, that shoreline zoning ordinance 15 QC, which states that vegetation less than 3 feet in height shall not be cut, removed, or within, I'm summarizing, obviously. So Greg, I think you'd be a good person to start on this one.
Well, I think if I've been cornered to treat it separately, I can't argue that my argument is of my perspective is basically rendered moot here. So if I'm just looking at 6 in isolation and not considering the duplicative nature of 7, then I would recommend that we uphold 6. But if we're not going to, because it clearly includes this, it includes some of 7. So I don't really have a way to move forward, and that's what I was kind of concerned with. But you know, my argument to re-articulate it was that the only unique thing that's been presented from the town is that I have noticed there are leaves and pine needles that I would consider ordinary coverage due to anybody's backyard that you rake up. And I don't believe, given that there's no definition of what are the terms, leaf litter and forest duff layer, we didn't get those defined well, that I think that it wasn't substantially differentiated. But again, now that I'm here, I have to consider the rest of the ordinance, and I think that it wasn't, you know, I recommend that we uphold it.
Sure, but I think one thing that that the board could do is, you know, what I would ask of the other board members is, do you agree with Greg's finding that the removal of forest duff layer or leaf litter on its own is not a violation of 6? Recognizing that there are, if I'm characterizing that right, you're saying is essentially it's so de minimis, it would just be an absurd result for that on its own to constitute a violation. Recognizing that because there are other violations that occurred, 6 is still going to be upheld, but you can still make that independent finding. And I think that's, if everybody agrees with that, that's something that I can certainly articulate in the decision. So I'm curious if others agree with Greg.
Greg, does it make a difference if it says, if you hear other ground cover, including leaf litter and forest stuff? Does it, if we expand that out where the ordinance says other ground cover, does that make a difference for you at all?
I think if it was defined and we could clearly classify with the visual what was demonstrated in the evidence, because what the point that I'm caught up on here, and I'm not trying to make this any longer than anybody that it needs to be, but the point that I'm caught up on here is when you look at the pictures, this is nominal. Well, this is just completely nominal cover. So like if other ground cover was defined somewhere that made it some sort of a unique thing that we could all agree, like, hey, there's a you know, the ordinance protects removing this. It's just, to me, what was demonstrated in the visual evidence was, if that's what this ordinance is in violation of uniquely, then this is, you know, the town's going to be really busy citing people, because those are really, that's a really low bar. And that's what so whatever it is, if it was defined, where you want to take other ground cover, forest duff layer, leaf litter, if there was a definition that we could use to look at that and say, yes, that's it, then I would be fine with it. The fact that there isn't leaves me to kind of look at it and just use my judgment. And Alex pointed to pine needles. And I just, you know, I don't want to, yeah, I mean, so yeah, if that's defined, then we could look at that. I think that would be really helpful.
May I break in just for a moment? Stephen, could I speak to you just offline? I think I might be able to help you here.
I mean, do we have to go offline for it? I'm not going to be embarrassed if you've got a better way to sort through it. We can talk candidly about it.
The town does not base this violation on pine needles.
Well, that's not, it's not what that's not how the question was answered. So, I mean,
I think I'd object to reopening this. I mean, the evidence is in, the arguments are in. I think the record in Alex's testimony speaks for itself, and council shouldn't be allowed to buttress it or change it or comment on it at this point.
Yeah, I believe that, you know, the board, I think the board can wrestle through this. Just given the ordinances presented to us and the information provided to us. I mean, I agree with Greg. You know, this was, you know, the pine needles is what was presented to him as this particular item. So, you know, I believe we can move forward with what we got presented.
So I think that the only comment I'd make on this, you know, I think this is really a factual issue, so I'm not going to really have a heavy hand here. I think it's up to the board to, you know, recall what it heard and make its findings. Granted, my recollection is that we've got, if anything, some mixed testimony. You know, I recognize that I think there was a statement from Alex about leaf litter being when he was directly asked about 6, but I would encourage you not to read that in isolation. Think about, you know, all the other testimony we've heard, and you know, consider the definition, which includes ground cover, small plants, fallen leaves, needless twigs. So you know, consider all of those issues as you evaluate this question.
Does any other board members want to voice anything to this?
David, it's just, I'm going from some memory here. Maybe somebody else can clear it up, but wasn't 6 the removal of vegetation under 3 feet, and violation 7 the part that said no permit to remove vegetation?
Correct. Yep.
So we're back to the 2, you know, the argument that duplication is the operative word was no permit in one and the removal in the other one. So.
Yeah, I think last time, you know, I think Greg and I were, with the last time we talked about this, it was you can't really remove vegetation under 3 feet. You know, that seemed like you couldn't do one without the other. There was no distinction between the two, at least presented to us, which is why we voted to consolidate. But with this, I know for myself, with this one, there was the distinction between the two where you can do, at least in terms of the ground cover, you can do that without a permit. So for me, there's a clearer distinction this time.
Are they both citing the same section 15 QC? Right.
No, 6 is 15 QC and 7 is 14 item line 5.
So take a look at 15Q. Let's see, let's follow this one. Never mind.
So I guess where are we at with this?
So I think I may have, you know, sidetracked this a little bit with trying to, you know, get a specific finding about pine needles. I think you can step back, look at it more broadly. We're looking at 6. generally, and, you know, take a look at the proposed findings of fact from the town on 6. Violation 6 should be held for the same reasons the ZBA upheld the violation in terms of 28 Whitetail. Looks at Exhibit D. Notice violation demonstrates there was vegetation in the rocks, and there was vegetation when there's now only dark mulch. It demonstrates the grass and shrubs provided protection of the slope were cleared and removed. It demonstrates the vegetation near the water and the rocks was cleared and removed. Demonstrates the vegetation was cleared and removed, and it was not done so to create a footpath or any other valid purpose, and therefore it's a violation of 15 QC. So one way to deal with this issue is, do you agree with those factual findings or not?
I would say yes for myself.
I say yes.
Okay, so would you agree therefore the evidence establishes that Big Lake Marine cleared or removed vegetation under 3 feet in height within 100 feet of the normal high water line in violation of section 15 QC?
Yes.
Yes.
Okay, and I would suggest a motion to uphold violation 6 based on those findings.
So moved.
Second,
All those in favor, David Murch, voting yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, so the next issue is to address section 7 independently.
Section 7, removal of vegetation less than 3 feet in height without a permit. Sorry, jumped off here. So all existing vegetation less than 3 feet in height, including shrubs and ground cover, has been removed within 100 feet of the normal high water line of Sebago Lake, referencing shoreline zoning provisions, section 14, table of land uses, item number 5, which is clearing or removal of vegetation for activities other than timber harvesting. I guess I'll, since I talked about this earlier, I do see that there has been clearly removal of vegetation for activities other than timber harvesting. There's no indication that a permit's been obtained for this. I appreciate the clarification in regards to how to look at this in terms of, did Attorney Braun present sufficient evidence to indicate that Big Lake Marine did not do the work? And I would have to say no, at least from my perspective. I appreciated the correspondences that were provided. Unfortunately for me, they weren't 100% clear. I wish Rob Durant would have been able to speak to those directly to us so that we could get a little bit more out of that about what was being referred to. But yeah, so I'm gonna say that this one be upheld.
I agree, Dave.
I agree.
I agree.
And does the board agree that the factual findings of its prior decision, recognizing that we were dealing with the consolidated 6 and 7 there, but to the extent that they apply here, those same findings, conclusions, and reasoning would apply here as applied to Big Lake Marine?
Yes.
Okay. So
You're not combining them, right?
No.
not combining them. Nope. I was just wanted to clarify that I would draw from the same factual findings. So I would suggest then a motion to deny the appeal in part and uphold violation 7 based on those findings and conclusions.
So moved.
Second it.
Second,
David March voting in favor.
Greg Dean favor.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Let me try this. I'm going to ask Attorney Wyckoff, can you clarify, did I interpret what you were arguing previously accurately to say that you were essentially asking the board to reconsider its vote to consolidate 6 and 7 as it pertains to 28 whitetail management controls?
I mean, Kaylee, no, I didn't make that request.
Okay. Appreciate that clarification. So for the board, you've got one decision where you've consolidated 6 and 7, and in one decision you haven't. Now, as you know, Attorney Braun mentioned, it's while the record is the same and the arguments are applied from one case to another, each one is unique. Different facts based on different presentations. So you don't have to reconsider that, but I will advise that legally you could vote to reconsider that prior decision. Yeah, Attorney Rachel.
I will look at the ordinance, but I actually don't think they can. My understanding of reconsideration motions is that they need to be taken within 10 days of the actual decision. I'll look in the ordinance. I think under the statute 38-269, 2641, that reconsideration motions must be made within that timeline.
Right. Our decision was tonight.
I hear that. Okay. Understood. Thank you.
Yeah, but does the reconsideration need to be presented by the appellant? There is something in the ordinance.
I would suggest to you that the board has that inherent authority to reconsider. That's what the statute provides. So I doubt that your ordinance provides something differently. That being said, it's entirely discretionary if you want to make that decision.
This be considered new business, or is this something that we do during this?
I suppose you're right that it would be new business, but I don't want to get hung up on procedure on this. Just, you know, do you think that's something that you want to address, or we could take this up after? I'm getting a strong sense that nobody wants to revisit it. We're okay with the difference in the decisions. It was slightly different facts, slightly different arguments. Is that accurate?
From my perspective, yeah.
Okay.
I'd be willing to reconsider.
Okay. Greg, Pete, Fred.
I'm not super interested in revisiting it,
Okay.
but
I mean, I voted the same way on the other one, so I mean, I don't know if it needs to be done, you know, for any legal reasons or as.
No. Attorney Wyckoff.
I only mentioned, I mean, if you don't reconsider now, I could make an oral request for reconsideration now. I could do that later. And as a practical matter, you may just want to deal with it now to save time and energy.
Ordinances said a Board of Appeals may reconsider any decision within 45 days of its prior decision. A request to the board to reconsider a decision must be filed within 10 days of the decision to be reconsidered.
So I still think that the board could decide to do it on its own, but perhaps let's make this easy and say, you know, I'm getting a sense from the board that it does not want to take this up on its own. So let's move on. recognizing that Attorney Wyckoff or any other party for that matter could move for reconsideration, and then we can take it up if that comes up. Does that sound good?
Does sound good.
All right. So, believe, just nod your heads, we did reach a vote on violation 7 to uphold it. Yeah. Okay. So the next issue is whether violation 8 should be.
Okay, violation 8, unpermitted shoreline stabilization, no permits, referencing shoreline zoning provisions. Section 15, land use standards, subsection C12, A, C12. So vegetation, let's see, vegetation may be removed in excess of standards of section 15Q of this ordinance in order to conduct shoreline stabilization of an rolling shoreline, provided that a permit is obtained from the planning board. So, no shoreline, yeah, I mean, shoreline, we've been presented evidence that shoreline stabilization was done. No permit was obtained by the planning board. So I feel this should be upheld.
Who did the work, and was there a permit? Or you said there was no permit. Sorry. I ask, one of the findings presented by the town is that the work was done by Big Lake Marine. Do you agree?
Yes.
Yeah. Yes.
So based on those findings, the board would conclude that the section of the shoreline zoning ordinance cited in violation 8, the evidence establishes that that violation in fact occurred.
Yes.
Okay, so I would suggest a motion based on those findings to deny the appeal in part and uphold violation 8.
So moved.
Second it.
In favor, all those in favor, David March, yes.
Greg Dean, yes.
Tom Hennessy, yeah.
Fred Miller, yes.
Steve Lockwood, yes.
Okay, the next issue is whether violation 9 should be upheld.
Unpermitted shoreline stabilization, no barge. Again, referencing same section, shoreline zoning provisions, section 15, item C, subsection 12, which states construction equipment must access the shoreline by barge when feasible as determined by the planning board. Yeah, the work invoice indicated that work would be done by barge as necessary. And we're not in a position of being able to determine whether or not use of a barge was feasible or not. Therefore, I think it's, you know, there was a violation here. They didn't get that decision from the board as to how it should be, planning board as how to move forward with this. So yeah, I believe this one should be upheld.
I believe so too.
Agree.
So can I infer from that that the board was not persuaded by the arguments it heard today about the distinction between the ordinance saying access, whether access was feasible versus the notice violation, you know, talking about the feasibility of the use of the barge for the actual work?
I wasn't, no.
I wasn't either.
I mean, I think they raised an interesting nuance in the language used, but I don't think they presented any evidence that would indicate that they did access it through the barge. So
Okay, fair to say that the same findings that the board made on this violation as pertains to management controls would apply here as it pertains to Big Lake Marine?
Yes.
Okay. And so therefore, based on those findings, you would conclude that Big Lake Marine committed the violations alleged in violation 9, or violated the sections of the shoreline zoning ordinance cited in violation 9.
Yes.
Okay. So I would suggest a motion that based on those findings, the board denies the appeal in part and upholds violation 9.
We 10 or 9?
We're on 9.
I'm sorry, I have to page, you're right. I'm sorry.
So moved.
Second,
All those in favor, David Merch, yes.
Greg Bean, yes.
Tom Hennessy, yes.
Miller, yes.
Pete Lockwood, yes.
Okay. Unanimous. Next issue is violation 10.
Unpermitted tree removal within 100 feet of Sebago Lake. Referencing shoreline zoning provisions, section 15 land use standards, subsection Q, clearing or removal of vegetation for activities other than timber harvesting. And further subsection 2A. This is talking about the canopy. There shall be no cleared opening greater than 250 feet in the forest canopy. Except for areas as described within a strip of land extending 100 feet horizontal distance inland from the normal high water line of a great pond or river to a great pond, or within a strip extending 100 feet for horizontal distance. Yeah, sorry, reading way too much here. So given the evidence presented, I believe this should be upheld.
Yeah, I agree.
I agree.
And again, in reference to Big Lake Marine not having done the work, I find that, again, the evidence presented is insufficient to indicate that they did not.
Yeah, same here. There's little indication of what those messages actually pertain to.
In addition to that finding, you would agree that all your factual findings and conclusions from violation 10 under the management controls for 28 whitetail would apply here as it pertains to Big Lake Marine?
Yes. Yep.
Okay. So therefore, based on those findings, you would conclude that the evidence shows that Big Lake Marine's activities violated the sections of the shoreline zoning ordinance cited in violation 10.
Yes.
Okay. So I would then suggest, based on those findings, a motion to deny the appeal in part and uphold violation 10.
So moved.
Seconded.
All those in favor, David Merch, yes.
Greg Bean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, that brings us to violation 11.
Vegetation removal in excess of what is allowed by the point system. Looking at shoreline zoning provisions, section 15, land use standards, subsection Q, this time 2B. Again, talking about selective cutting of trees within a buffer strip. Again, given the evidence that was presented, I believe this should be upheld.
I agree.
Agree.
Okay, and would the board agree that the same findings from its decision pertaining to management controls 28 whitetail would apply here as pertains to Big Lake Marine?
Yes.
Yes.
Okay, and the board would agree that therefore the evidence establishes that the Big Lake Marine conducted activity that violates the shoreline zoning ordinance sections cited in violation 11.
Yes, and I guess I would add, like we did in number 10, that the evidence presented that Big Lake Marine did not do, there was insufficient evidence to indicate that Big Lake Marine, did not do the work, or however that's to be said.
So then I would suggest a motion to uphold or to deny the appeal in part and uphold violation 11 based on those findings. and
So moved.
conclusions.
Second it.
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, that brings us to violation 12.
Removal of vegetation without a permit, referencing shoreline zoning provision, section 14, item number 5, clearing or removal of vegetation for activities other than timber harvesting. I would argue that that is duplicative of number 7, which also references the exact same shoreline zoning provision item. So I don't,
I agree. Dave.
yeah, I find that one duplicative.
Yeah, I actually think the question maybe to think about this, because I know we had a 2-3 vote on this, and we're referencing our previous decisions to provide some context and raw reasoning here. I think that one thing to think about that as I listen to the testimony and people speak today is I think we're just determining whether or not the ordinance was violated. There's a whole separate part, in my understanding, to do with the magnitude of the violation. And so the idea that you could do a per tree violation, like maybe you could write the NOV that way. Yeah, sure. But I think like it's just playing fast and loose with how you divide things up. I think that Attorney Braun made a fairly compelling argument that this could be used in any number of ways to kind of just make it really, really painful and arduous to appeal something if you have to appeal on a tree by tree basis or a square footage basis. So I found that as a compelling argument that this is really, yeah, there was a lot done. Like these can be duplicative, and it can also be a huge violation. They don't have to be two separate violations for it to be encompass a lot of different things. So I think they're duplicative.
Hey, Dave, can you, on this 12, does this have a, if my memory serves me right, doesn't this have anything included beyond 100 feet from the waterfront? Because I
On
think
this one, it was written up as between the house and the water, vegetation has been removed from a 1,250 square foot area without a permit from the code enforcement officer.
and the other ones were within 100 feet. And this is, and
Well, number 7 was written as all existing vegetation less than 3 feet in height, including shrubs and ground cover, has been removed within 100 feet of the normal high water line.
with or without a permit.
Without a permit. Thank you. Yep, without a permit.
And that was within the 100 feet, you said, right?
Correct. It was written up that way, but I would argue that the shoreline zoning provision that was indicated, or used to reference, makes no distinction of
Like the
100
line
feet
four.
of the high water line.
10 and 11 are the 100 feet. Point system, canopy coverage.
I mean, I remember if I based my fact on before, there was trees up by the house that was cut. And that's why I didn't go along, because it did hit that point factor up there where the 6 and 7 were within the, well, 6 was below 3 feet and I think 7 was above 3 feet, but it was in that 100-foot area. And the pictures showed that there was, areas cut up beside the house, in front of the house, that fell into that point system. And I believe that's what I based my facts on last time.
And the point systems under number 11, violation 11.
Mhm.
I still am focused on the fact that it's the exact same ordinance item being referenced for two things. And there's a distinction, being made with this within the write-up, but the ordinance doesn't have that distinction written up in it itself.
Yeah, I think that's a key point, David.
But did we uphold it last time as a violation?
So last time, you took last time you addressed the argument of duplication of 12, but ultimately it took one vote and two members, Greg and David, voted to vacate. So the motion was to uphold, and so they voted against that. And they did so on the basis that it was duplicative. But a majority of the board voted to uphold 12. So I would suggest the same motion here. So let me say this: a motion based on the same findings and conclusions of the decision in MCL 28 Whitetail as applied to Big Lake Marine, in addition to the other factual findings discussed here. The board concludes that violation 12 should be upheld.
Obey it.
So we've got a motion. Do we have a second to uphold 12?
Well, I'll second it just so we can talk about it.
Yep. So now it's queued up for discussion.
So I guess I would be interested, Fred or Pete or Tom, how you would look at this.
I think one of the discussions the last time was that 12 was different in the fact that it was again, no permit to do tree removal. So.
Yeah, 12 that is correct. 12 is no permits. 7 is also no permit. So there's no distinction there in terms of
it's
the.
over 100 feet is where I think that is where I'm based it on, because looking at the pictures, there was definitely trees cut beside the house and in front of the house that would be past that 100-foot mark.
Right. But again,
I
from
said
my perspective,
that then they'll cut down the trees that they weren't supposed to be cut down. They did it without getting authorization or a permit to cut trees outside that line that the other two violations covered.
Well, that's yeah, but I think we're talking about 7 and 12.
Right.
Yeah.
7 should cover. Well, I think what David and I are suggesting is that 7 and 12 both cover those trees. Anything.
Yep. Yeah. As it's written, clearing or removal of vegetation for activities other than timber harvesting. That's what our ordinances say. It makes no distinction about where or within what range. And it was written up in the notice of violation, one talking about removal within 100 feet of the normal high water line. That was number 7. Number 12, talking about the vegetation being removed within 1,250 square foot area. But why is there a need to make, how can we, where is that distinction coming from? Can't, I'd argue, can you make another another violation fall under this? I just have a hard time with this particular ordinance item specifically saying clearing or removal of vegetation for activities other than timber harvesting, and it doesn't establish any sort of radius or area or with it how we can use it for two separate items. I believe the two should be combined to one or this one vacated.
So I've got a good sense of where 3 members are and where 2 members are, so. Not to cut it off, but
Nah, that's fine. I agree with you.
Can I just say one more comment before we go to vote on it? David?
Yeah, of course. I'm sorry, Greg. Yep, go ahead.
I just want to reemphasize that by no means does this mean that things that were done that violate 7 won't be accounted for in terms of like the measuring the magnitude of the violation. I'm merely trying to encourage everybody to look at like the unique ordinances that were violated. The magnitude is not something we really need to be addressing right now. So my recommendation would be that use that framework. And unless somebody wants to correct me, that's the framework I'm using.
no, I think that's clear. I understand.
So we'll go ahead and move forward with the vote. David Murch voting no to uphold.
So wait, I thought we were voting to consolidate.
No, so the motion is to uphold 12.
Okay, so then I would vote. But Greg Dean, no.
Tom Hennessy, yes.
Fred Miller, yes.
You like what I'm going to say no.
Okay, so that's a vote to vacate 12. That is, so the motion to uphold 12 has been denied, thereby vacating 12. Pete, can I ask, do you agree with the reasoning of David and Greg?
Yes, I do.
Okay. I don't think you have to have a separate motion to consolidate 12 and 7. You know, I think we had those previously because of the nature of how Attorney Rachel presented the argument. I think that just the motion to grant the appeal in part, the effective motion to grant the appeal in part and vacate 12 is clear enough. So I'm satisfied that we've addressed that issue. So that brings us to the last issue, which is Big Lake Marine's argument that the work performed met the requirements under the permit by rule process and the Town of Raymond shoreline zoning provisions. The town rejected that, said that the work did not meet the requirements of the permit by rule, cited the DEP letter, and then Officer Soroy testified that the work also did not meet the requirement of the Town of Raymond's shoreline zoning ordinance. So any discussion on that issue?
No, just given the evidence provided, I would agree that it did not meet what needed. Yeah, it was not sufficient to do the work.
I agree with that.
Okay, so I would suggest a motion then to deny the appeal on the grounds that this Big Lake Marine's activity would meet the permit by rule standards or otherwise satisfy the shoreline zoning ordinance. So a vote in favor of that would be in favor of the town's position.
So moved.
Seconded.
David Murch voting in favor, yes.
Greg Dean, yes.
Tom Hennessy,
Fred Miller, yes.
Be Lockwood, yes.
Okay, I apologize for the terrible wording on that last one. But, so I've got preliminary findings of fact and conclusions on all of the issues here. As before, I would just, without opening it up, you know, the broad argument, but just any of the attorneys or board members think that we've forgotten a issue that was raised that needs to be addressed?
I don't believe so.
I'm seeing shaking heads, so I will get this out in advance of the meeting on 8 o'clock on November 1st. If there's going to be any motion for reconsideration of anything, I would encourage getting it in advance of that. so we can address it.
I think
Okay.
that'd be me filing one, and I think I will do that so that the decisions conform.
Yeah.
Similar. With respect
Actually,
to-
Leah,
I'm
Yeah.
okay with inconsistent decisions.
maybe if I can just suggest, Leah, maybe you and I should talk offline about that.
Sure, happy to.
Yeah, to the extent that there could be any coordination on that to make everybody's lives easier, I'd certainly appreciate it. Well, I think that's all I've got, so I turn it back to you, Mr. Chair.
Okay, well, I'm gonna echo other sentiments. It's been a long road here, so thank you everyone for your patience with us and for everything you presented. Thank you, board members, for doing all the hard work as well. So I will take a motion to adjourn.
So moved.
Second,
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Be Lockwood, yes.
All right. Good night, all. Thank you, Sandy.
David, before you jump
Thanks,
out,
David.
Yeah,
we didn't get anything new in for the November regular meeting. However, you guys had tabled that Coleman Furnish one to the November meeting. I didn't get anything from them. The last I spoke with the attorney, she said that they hadn't had the survey yet. So you guys might want to decide to keep it tabled and we'll notify them, or you may want us to put out the agenda and see what happens.
I believe, well, yeah, we did, yeah. Let's talk
Okay, yeah.
later. Okay, we'll
Okay.
talk about it tomorrow.
All right.
Sound good?
Yep, I'll be in the office until 1.
All right.
All right,
Awesome.
Okay.
everyone.
All right. Good night,
Bye.
everyone.
Good night.
Thank you for your time.
Yep,
Of
thank you.
course.